You ready? You turn the heat back on?
Wait, hold on. I forgot my.
Okay. And we're rolling, right?
Oh, wow. Nice.
Okay, welcome to the penultimate edition of the Township of Ocean Board of Adjustment. Nicole, can you take a roll, please?
Sure. Mr. Ashkenazi?
Here.
Mr. Delomo? Ms. Deal? Mr. Chamorro?
Here.
Ms. Littman? Here. Mr. Fuccielli?
Here.
Mr. Lineski?
Here.
Mr. Caramanica?
Here.
Vice Chairman DeGennaro?
Here.
Chairman Cole?
Here, please rise to salute the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The notice requirements of the open public meeting law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk. There are emergency exits through the courtroom doors in the back and two exits at the, or actually this is the back and then the rear of the room. That's always gets me. No smoking, please, as we all know. Board policy, no new cases will be started after 9 p.m., so we're going to try and get to all of these. No new testimony taken after 9:30. In addition, the applicant will be limited to 45 minutes of testimony. All meetings will be video and audio taped and shown on the Township of Ocean's Community Cable Channel, Channel 22 on Verizon Fios, Channel 77 on Cablevision. Please turn your cell phones off. If you need to make a phone call, please leave the room. Resolutions for memorialization. We have 1, 2, 3, 4. We have to do them individually. They can be done together. Okay. We have Jeff Barnes, 8 Klein Street, Block 33, Lot 13, in the R4 zone. Joseph Fontana, 117 Cold Indian Springs Road, Block 37.04, Lot 5. 149 Chatham LLC, 149 Chatham Avenue, Block 25.05, Lot 6. And Mark Sith, 508 Palmer Avenue, Block 62, Lot 12. All in favor?
Okay, you gotta do it first and second.
I'll make a motion for positive
I'll
resolution.
second.
Okay. All in favor? Aye.
Aye.
Any opposed? Hearing none. Okay. Old business. We have a few things that are going to be carried, so we should announce that, correct? 260 Overbrook Avenue LLC, 260 Overbrook Avenue, Block 22, Lot 40 in the R4 zone. This case will be carried to Wednesday, June 17th with new noticing. If you're in the room to hear this case, it's going to be heard in this room on Wednesday, June 17th, 2026.
You will not receive any further notice, right?
There will be new notice.
Oh, there will be new notice? Okay.
Yeah. Abraham Benatar, 517 Laurel Avenue, Block 68, Lot 6 in the R5 zone. That will also be carried to Wednesday, June 17th, 2026 with new noticing. So if you're here for that item, come back here on Wednesday, June 17th.
Excuse me, Chairman.
Yeah.
We also had 251 Howard. It's my error that I didn't put it on the agenda. They did notice for tonight's meeting.
Okay.
There was a problem with the plans. So they asked if we would carry it with no new noticing to the June 17th.
Okay, so that's 251 Howard? Okay, so you may have heard that we were going to hear a case for 251 Howard. We are not. That's going to be also moved to Wednesday, June 17th. Is that right?
Correct.
Okay. Finally, Township of Ocean, 1313 South Roller Road, also known as Block 142, Lot 36. That will be carried to Wednesday, June 17th, 2026, with no further notice on that one. Is that everything? Okay. All right, now on to old business that we'll actually hear. 2 Texas Avenue LLC, 219 Lewis Street, Block 17. Attorney for the applicant, Jeffrey Donner.
I'm here, Mr. Chairman.
Hello, sir.
I'm delighted to start, but Mr. Akins, my good friend, has indicated he's in a time stress. He has an application. He said it's not going to take that long, and I've agreed to let him go before us.
Okay.
It's a professional accommodation.
Very good.
Thank you, Mr. Miller.
Thank you, Mr. Donner. Thank you, Chairman.
Okay.
Board members.
So that means 260 Howard Family LLC, which is 260 Howard Avenue, Block 49, Lot 9, in the R4 zone. Attorney for the applicant, Mr. Mark Akins.
Good evening, Chairman, board members. Mark Akins on behalf of the applicant, 260 Howard LLC. As I'm setting up, if council could just confirm that my service by publication and certified mail is in order, and then I'll...
And I can mark the following exhibits into evidence. Exhibit A1 will be the variance application itself. Exhibit A2 will be the boundary and topographic survey. Exhibit A3 will be the architectural plans. Exhibit A4 will be the plot plan. Then I have the following board exhibits. Exhibit B1 will be the zoning officer's report. Exhibit B2 will be the board planner's report. Exhibit B3 will be the board engineer's report.
Thank you very much. Ladies and gentlemen, by way of application and background, this is an existing two-story single-family residence at 260 Howard Avenue, which is proposed to be removed. A new residence of 2 stories is proposed to be constructed. This property is slightly undersized at about 7,800 square feet, where 10,000 square feet is required in the R4 zone. The property is also undersized in lot width at 78 feet, where 90 feet is required. The property has some topographical constraints as well. It's high in the back, and then the elevation drops to a lower elevation by about 8 feet during the 100 feet depth of the property along Howard Avenue, and that's an approximately 8% grade change if my math is right. So variances are sought this evening for the front step setback along Howard Avenue, where 30 feet is required and 27.43 feet is what we're proposing. A combined setback for the basement areaway, because we do have a bedroom basement that's proposed, at 23.14 feet, where 25 feet is required. And then, as I referred to earlier with regard to the topographical change, a change greater than 2 feet with regard to the topography and grading at the property. With that, I would introduce the applicant's team this evening: Edward O'Neill, an architect to my right; Patrick Ward, a licensed professional engineer and licensed professional planner to my left. And at this time, Chairman, I would call Edward O'Neill and ask that he please be sworn.
Okay.
Thank you.
Mr. O'Neill, do you swear your testimony you're about to give will be the truth, the whole truth, nothing but the truth, self you got?
I do.
And just confirm your name for the record.
Edward William O'Neill Jr.
And you are a licensed architect in the state of New Jersey?
Yes.
And your license is in good standing?
Yes.
Thank you. Go ahead.
Just want to grab my notes.
Please do. Good evening, Mr. O'Neill. Can you review with the board the existing conditions present at the property?
Well, again, the site is slightly undersized. What is being proposed is a new single-family residence, which would have 1,890 square feet on the first floor, 1,756 square feet on the second floor. It has a finished basement of 1,771 square feet.
And do you have elevations to review with the board?
Let's do.
Referring to A3 as identified by the board's counsel.
Thank you. So these are the proposed elevations. You see front elevation, right, rear, and left side. So the total height to the peak is 31 feet, 5.5 inches. It would be a stucco finish. The stucco finish is kind of an off-white. It would have wood siding accents here. The front elevation would have a metal roof. The others are more of a standard asphalt roofing shingle. There would be black aluminum railings, dark bronze windows, cream limestone accents, again, in certain parts of the sides have stone.
Terrific. And all new construction, correct?
All new construction, yes.
Great. So that'll meet building, fire, and safety codes?
Yes, as a matter of fact, one of the variances has to do with one of the life safety codes in the basement.
Okay. And can you take a moment and review that with the board? That's the one where we identified as the area away from the basement, correct?
Right, so I'm going to go back to the, this is the proposed basement plan. So these 2 bedrooms are technically underground, but they're at the basement level. They require 2 means of egress. One means of egress is the main stair of the house. The other has to be directly outside. It's no different than one of the bedrooms on the second floor having a window that meets that requirement. So there's actually a company in Lakewood which pre-manufactures these egress windows for basement conditions. Their name is Bowman Kemp. And so we have one suggested for each bedroom to make them fire egress code compliant.
Terrific. Okay. And those are shown on sheet A101 of your plans, correct?
That's correct.
And it's your testimony that that would be part of the applicant's installation and construction should the board deem fit to approve this matter.
Yes, and just to make sure everyone understands that the areaways, the top of the areaway is at grade, so they don't protrude up in the air. They're maybe a few inches.
So when you're driving along Howard, you don't see them?
No, you would have to be almost on top of them to see them.
Terrific. Great. Chairman, board members, I have no further questions of Mr. O'Neill.
What's the current square footage of the first floor now?
The existing structure, may I defer that to the engineer?
Oh, okay.
I'm guessing he has that calculation. Thank you very much.
1,262 square feet.
Any questions for this witness?
Thank you.
Anybody over there? No? Okay.
Actually, you know what, I'm afraid.
Sure, roll off.
Okay. Applicant now calls Patrick Ward, licensed professional engineer, licensed professional planner. Ask that he be sworn, please.
Mr. Ward, do you swear in testimony about to give will be the truth, the whole truth, nothing but the truth, so help God?
I do.
And just state your name for the record.
Sure. Patrick Ward, WARD with Insight Engineering.
And you are a licensed engineer and planner.
Yes, I am.
Okay, thank you.
And your credentials are in good standing?
Yes, they are.
Terrific. Thank you. So, Mr. Ward, you've heard the testimony of the architect, Mr. O'Neill. You're familiar with the site.
I am.
You've prepared the plot plan.
Yep.
And the relevant exhibits associated with that plot plan. What can you tell the board about the engineering, drainage, and related issues in connection with this application?
Yes, absolutely, you can.
No, I know. Yeah, so what I'll do is, excuse me, I will start with the existing conditions because some of that has to do with one of the variances we're seeking tonight. So this is the survey, I believe it was marked as A2. And one of the things I did want to point out, besides the fact that there's an existing 2-story dwelling, our westerly side yard setback is non-conforming by a few inches, is the topography. And Mr. Akins alluded to this. The curb line is at elevation 30 to 31. And in the back corner here, we're above elevation 39. So it is about 8% slope. You'll also see on the survey that there's a concrete retaining wall along the west side. That's really, from what I gather, was done to provide some sort of usable rear yard for this home when it was built. We're proposing to remove all existing improvements. So what we're proposing is a new 2-story home. This is a new exhibit, if we want to mark that.
Exhibit A5.
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 What would you call it, a colorized?
Yeah, colorized rendering. The date of that is May 27th, 2026.
Okay.
So, new 2-story dwelling, starting at the front, we have a fully compliant circular driveway for the front yard area. It does meet all the required quantity of parking per RSIS for the number of bedrooms we're proposing. Along the left side of the home here is the mechanical equipment. We show AC units and pool equipment. And as you get to the rear yard, there is a pool patio area and a swimming pool that we're showing. There are 3 qualifying trees on the property today that we're removing, but based on the tree ordinance, we're permitted to remove those 3 without replacement. We are proposing 2 street trees, as you see on the plan as well. And now for the grading of the property, which is really one of the variances we're talking about. That's why I wanted to talk about the existing topography. I'm going to turn to sheet 3 of 7 of our plan set, which is our grading plan. Just kind of explain why we did what we did. So we designed the grading of the property to work with the existing slope from the rear to the front, really to accommodate the new home footprint without the need for any new retaining walls. So that existing retaining wall is going to be removed, and we don't want to replace it. So what we do is we slope the front yard up to the front of the home. It's about a 3-foot grade change across that front yard. And the goal here, by doing that, was to try to minimize the number of steps at the front. So we have 3 steps as currently proposed. At the rear, we have just 1 step out onto a patio, step down onto the proposed patio area. If we added any more steps at the rear, it would require more steps at the front. We were trying to avoid that. So then, in order to make this rear yard usable and suitable for the pool and some limited patio space, what we have to do, as proposed, is raise there's a low part of the backyard really on the east side of the pool area. By raising that, we do exceed the 2-foot grade change rule. But as you can see, we're not trying to raise the backyard all the way up to where the rear property line is. We still do have a slope in the southwest corner of almost 3 feet up to the corner. So the pool area sits a good 2+ feet lower than the neighbor behind us, and also to the west. The runoff condition mimics the existing. Most of the site drains towards Howard Avenue today. There's a small sliver on the east side that does drain to our neighbor to the east. By raising this backyard area, it actually is advantageous to us because it allows us to then drain everything, almost everything except for the side of the berm that we're proposing out to Howard Avenue. So we're improving the drainage condition as a result. The limits of the dwelling, the actual building envelope, the pool, the patio, the driveway, the mechanical equipment, and all the coverages comply as proposed, but we are seeking variances for some other pertinent items. So the existing lot area is non-conforming at 7,878 square feet, where 10,000 is required. The lot width is non-conforming, 90 feet is required, and we have 78.02 feet. The front yard setback is required to be 30 feet. The building's at 30.43 itself. The steps protrude as proposed into the setback, and their setback is 27.43, and there's 3 steps. The steps are uncovered, and in my opinion, will have a limited visual impact from the street. The minimum both side yard or combined side yard setback variance we're seeking is really as a result of the window wells or the areaways as were described before. The combined side yard setback is 25 feet. As proposed to the walls of the home, we're at 26.47, so that exceeds the requirement. However, because the window wells are treated as part of the building, the combined setback is 23.14, so it's a deviation of just under 2 feet. The window wells, as Mr. O'Neill said, will be flush with grade and not visible. They do conform to the 10-foot setback on this side. They're actually proposed over 12 feet away. Again, the exterior walls of the dwellings fully comply with the setbacks, with a little bit of room to spare on each side. And we are eliminating an existing side yard setback nonconformity on the west side. We are also seeking a maximum grade change in the rear yard area, where 2 feet's the maximum, and we're proposing a grade change right here on the east side of the pool of up to 3.8 feet. So, in terms of the variance justification, in my opinion, the grade change can be analyzed as a C1 hardship variance due to the unusual topographic condition of the property today. The existing topography limits the extent to which the property, and specifically the rear yard, can be developed by right. By requesting this grade change while also avoiding new retaining walls, we actually see a benefit of a more advantageous grading scheme to direct runoff to the street and not to the neighbors. The combined side yard setback variance, which is triggered by the at-grade window wells, can also be analyzed as a C1 hardship as a result of the narrowness of the lot. If this lot were the compliant 90 feet, they would comply, but the narrowness limits us here. The front uncovered stair encroachment can be analyzed as under the flexible C2 criteria, In my opinion, it's a de minimis deviation, especially since the stairs are uncovered, and there's only 3 of them. The following purposes of the municipal land use law are advanced. Purpose C, adequate light, air, and open space is provided. Nearly all the improvements are compliant with the ordinance, even though we are on an undersized lot. The small stair encroachment does not impede light, air, and open space. The front step encroaches 2.5 feet into the front yard. The steps are uncovered, and in my opinion, light, air, and open space is maintained here as the ordinance intends. Purpose E, this application promotes appropriate population density. Although the lot is undersized, the home and improvements are nearly fully compliant. This is an appropriately sized home on this lot, meeting the building coverage and the height, and it's appropriate for the zoning district. The stairs don't contribute to building mass or the floor area. And purpose I, this project promotes a desirable visual environment. The development of this property represents an aesthetic upgrade to the property, and the stair encroachment has no effect on the aesthetics. They're designed to be as inconspicuous as possible. When we analyze the negative criteria, we must determine if any of the relief sought has an impact on the public or neighboring properties. So starting with the grade change variance, there is no impact in my opinion. We're actually improving the grading condition on the property, allowing nearly all runoff to be directed towards the street. The window wells are to be constructed at grade and are intended to be imperceptible from the public right-of-way or our neighbor to the east. The intent of the side yard setback regulations is to ensure there's adequate light, air, and open space between the houses and to create a rhythm on the streetscape. While they do meet the single side yard setback, the minor intrusion into the combined side yard of this at-grade feature has no impact on that streetscape. And then the front setbacks have little impact visually as well. They're uncovered and slightly above grade. I believe the encroachment is de minimis in this case. Like the side setbacks, the intent of the front setback is to ensure adequate light, air, and open space in the front yard. Steps have no impact on the light, air, and open space here. So to summarize, this proposed development would not cause substantial detriment to the public good nor substantially impair the intent and purpose of the zone plan. And on balance, it's my opinion that the benefits of the application substantially outweigh its detriments, if any, giving the board the ability to approve the application with confidence.
Thank you, Mr. Ward.
I have a question.
Sure.
The proposed placement of the AC unit?
Yeah.
The pool equipment, is that still, once it's placed there, does that still fall within the setback limit?
Those meet the required setback of 10 feet. Yeah, they're beyond the building, the combined building, but they're not, that doesn't apply to those features. So they're fully compliant.
Do you know how close the neighbor is, the adjacent property, or what is there? Was there a garage, with the bedroom windows? I'm just curious.
I don't know what exactly is interior. This A5 here shows the aerial. So we have, it's about 15.5 feet to the wall of our house. The equipment and the areaways or the window wells are 12 feet. This appears to be about 6 feet over on lot 48 to our east. So it's about 18 feet between the structures.
And just a couple of follow-ups, Mr. Ward.
Yeah.
Any problems complying with the requirements of Mr. Higgins' letter of May 11th?
No issues with the,
I think the revised plans that were submitted did comply with those comments. It's just
Changing the building height
I was away, so I didn't have time to do a revised report.
and the labeling of the bedrooms?
Yes.
Great.
Yes.
Thank you. Terrific. And with regard to Mr. Matlack's comments, can you provide some testimony in particular with regard to the 5-foot aluminum fence?
oh, sure, yes. So, this doesn't show it as well. I'm looking at sheet 3 of 7 now on our plan. There was a question raised. We're proposing a pool, so we have to have a compliant pool code fence, which requires it to be fully on our property. We can't rely on a neighbor's fence. The odd thing here is to our west, which is lot 36.01. Their fence is about, I would say, 6 feet off the property line. There's a 6-foot chain link fence.
Yes.
So the concern is what maintenance there. It's not our property to maintain. We could put a gate there for maintenance, but I don't think it's our responsibility. We're proposing a pool fence again, it has to be our fence. We can't rely on the neighbor.
Is there, I guess in the existing condition, there are sections of fence that run perpendicular to that fence.
Yes.
Are those going to stay because that looks like that'll just create a locked area where you can't get into.
So, yeah, we would end that perpendicular section at the property line as proposed. I think it would behoove us to talk to that neighbor about maybe fully eliminating that perpendicular section. It's again, it's a little, I think the prior owner of our property had the benefit of that 6 feet because of where the fences are, and they probably thought they had it, but it's pretty, there's vegetation over there, so it's not exactly like lawn space that you'd mow every week. But I think we could work with that neighbor and just let them know where our fence will be, if they need to put a gate in or what have you, or maybe relocate their fence.
Yeah, I mean, I might defer to our attorneys. Is that something that can be conditioned, that agreement of the neighbor to remove that section of fence so that you can access it?
The problem is the neighbor doesn't agree.
Right.
That's what the problem is.
Right.
We have no control over the neighbor.
We could certainly agree to remove, the perpendicular section that's on our property. That's no issue there. And we can request of the neighbor. I mean, like, see, no objection for us requesting, I'll make that proffer for the board's consideration. No problem reaching out to the neighbor as a request, but of course, we don't control the neighbor's property
It's their
rights.
fence and their property, right?
Yes.
Is the neighbor here by any chance? No, okay. Figured I'd ask.
It's not the applicant's property, so I don't know if that, I guess that means that it's not not their concern, maybe not part of the application.
It's the best kind of problem.
It's just something that I wanted to bring up that maybe make the board aware.
Are you okay with the testimony on the grade change?
Yes, the testimony was that the drainage patterns are being maintained or improved, and I agree with that. Everything's still sloping towards Howard Avenue, so I don't have a problem with it.
Mr. Ward, would you say confidently that under the plan, less drainage or less runoff will go to the neighbor's property?
Yes.
Any other questions? Any questions from the audience? Come on up, sir. We'll need you to come up and grab the microphone, sir.
Can I bring him the microphone?
Yeah, you want to bring it to him?
Yeah.
Great.
Yep.
Right, so I'm just going to swear you in. Do you swear in testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
And just state your name for the record
Norm Ginsburg.
and your address, Mr. Ginsburg.
I'm at 258 Howard, house immediately adjacent to the east.
Okay, go ahead.
Yeah, my only concerns, some of which have been met, particularly the drainage. But I do have a question about 3 air conditioner condensers, which you haven't mentioned and may not be the need a variance for, but I would like to know where those air conditioner condensers will be placed. Will they be between the new house and my house?
We can show you. Pat, can you flip that? So that
Yeah.
It's right on the,
Got it now.
Yeah, so they're proposed on the east side.
On the east side, that's nice. Facing us, you mean?
so is that your house?
Yes, it
Okay,
is.
that's your house.
Yes.
I believe that, again, your air conditioner, and again, not to say that this is a problem for us at all, but your AC, I think, is at the front.
That is correct.
Front right corner facing from the street.
Mm-hmm.
So these comply. They have to be 10 feet minimum. They're at 12 feet, so they're a little.
Okay, so the separation from the property line on the east is 12 feet, not the 10
The
feet?
air conditioners, the house will be 15 and a half feet off.
Oh, okay. That's fine. And you explained the grade change, and et cetera. I think that's all my questions. Thank you very much.
And can we just make a general announcement that anyone talking even if you think you're whispering, please don't do so because the tape is actually picking you up. It's very sensitive.
Any other questions? Any comments on this application?
Applicant rests, Chairman, board members. Thank you for the opportunity to make the presentation.
All right, so we'll close the public hearing. Do we have a motion?
Motion to close.
Second.
No, we closed it already. We had motion for approval.
I'll motion for public.
There we go.
All right, Mr. Ashkenazi?
Yes.
Mr. Chimura?
Yes.
Ms. Lippman?
Yes.
Mr. Fujiali?
Yes.
Mr. Lineski?
Yes.
Vice Chairman DeGenaro?
Yes.
Chairman Fuller?
Yes. Thank you very much.
Thank you very much, ladies and gentlemen, and thank you, Chairman and board members, and Mr. Donner for the accommodation. Good evening, everyone.
Okay, next we have 2 Texas Avenue LLC, 219 Lewis Street, Block 17, lots 26 and 44. Mr. Donner, I don't know if you think that was quick or not, but you could tell us
Did my best,
after
Chairman.
Mr. Akins leaves.
Good night, Nicole. Thank you. Good luck.
So as we start, Mark, I think you have to handle.
We have a bunch of housekeeping to do on this one, so just give me a moment.
Yeah.
All right. When we were last here, Mr. Chairman, well, originally we came here in September. And in September, we got up to Exhibit A6. We then returned in November, and we were here briefly, and I'm told by Nicole, which is, I'll take blame for it, that we did not mark anything in that evening. So I just want to deal with that for housekeeping purposes. At that point, we had architectural plans, which were revised through November 4th, 2025. I'm going to mark that in as Exhibit A7. We had a plot plan, which was revised through November 6th, 2025. We're going to mark in Exhibit A8. We then had the following additional board exhibits. The zoning officer's report dated November 14th, 2025 was Exhibit B4. Board's planner's report dated November 18th, 2025 is Exhibit B5. The board engineer's report dated November 17th, 2025 was Exhibit B6. So that then brings us to today. And we have the following additional exhibits this evening. Exhibit A9 are going to be the architectural plans, which have now been revised through February 27th, 2026. That's Exhibit A9. And the plot plan, which has now been revised through February 16th, 2026, is going to be Exhibit A10. And then we have the zoning officer's report, which is now dated March 24th, 2026. That's going to be Exhibit B7. Board planner's report, which is dated 3/18/2026, is going to be Exhibit B8. And the board engineer's report dated March 13th, 2026, is going to be Exhibit B9. So that should be everything. There's also the drainage report, which was marked a while ago. So I think we're okay as far as that. Mr. Donner, is there anything else that you can think of that we need to mark?
I just have 2 additional exhibits. We introduced these photos last time, but sort of incompletely, so I would like this as the next A exhibit in order.
It would be A11, and this is just the photographs of the interior?
The interior of the existing building, which shows the commercial use of building cabinets. So it's an issue as to whether that can establish that use. My client, Mr. Matut, will in fact testify that he took these pictures and they are accurate portrayals of what the interior of the premises looked like at that time.
So those are 6 photographs on 4 sheets, and that's Exhibit A11.
Correct. And then we have A12. I have a larger size of this, but for purposes of your convenience, this would be the next exhibit. This is just a rendering of what the new design of the renovation will look like.
All right, so that's going to be A12 is a artistic rendering of what the house is going to look like. Yes. Okay, that's fine. All right, so yeah, hold up till we get to it. And then, Mr. Donner, I know for the record, I received an email from you at I guess you said about 4:30, I saw it about 5 o'clock tonight, over an issue which I know that Mr. Asadi, who's representing an objector, had sent a while back arguing over whether this is actually a through lot or not in the rear.
Came with my.
I know you actually noticed, I just reviewed your notice at the beginning of this hearing, you actually noticed for the through lot
Right,
issue.
Even though we dispute it, but.
You
for purposes
dispute it
of
and you note that in
jurisdiction,
your notice,
I want
yes.
the board to have the jurisdiction.
So
to deal with
it's
it.
in there, but I think in order to proceed, just so we all know what we're doing here tonight, that we should probably argue that issue first
Okay.
and get the through lot out of the way.
Great.
So if you want to start, and then I'll let Mr. Asadi come up and rebut, and then you can answer, and then the board can make a ruling.
Absolutely. Members of the board, thank you for the opportunity to allow me to make this presentation regarding whether or not 219 Lewis Street is in fact a through lot. Now, the definition of a through lot under the land use ordinance is a lot that flows from one street to the other. In our case, if we are a through lot, it would flow from 219 Lewis Street, where we're situated, back to Jerome Avenue. But as we will see, and I have some details, and Mr. Zanilla, who is our engineer tonight, will point it out on his engineering plan what I'm talking about. Jerome Avenue does not abut our property. Our property consists of Lot 26, which is where the residence that we're proposing will be located, and Lot 44 that we're looking to consolidate with Lot 26, which is at the rear part close to Jerome Avenue. But Jerome Avenue is only improved up to a point that is before the rear line of 44, okay? So what is the continuation of Jerome Avenue is basically trees and woods and impassable, and it's not a functional roadway whatsoever. So when we look at the facts, the question becomes, do we need a front yard variance because we have some type of a through lot with functional frontage on Jerome Avenue? Or are we looking at that as a technicality because Jerome Avenue hasn't been improved up to our lot, but technically there's a right-of-way that could be improved? But we're called upon, I believe, and I'm going to give you some authority in this direction, that when you read the zoning ordinance, we're not there to look at hyper-technicalities. What we are there is to look at what is actually being dealt with and what is the actual function that we're talking about. There's no doubt that our property at 219 Lewis Street is oriented to a front yard on Lewis Street. And there's no potential frontage whatsoever that we could be oriented to Jerome Avenue for a second front yard. So we're not a through lot. And the one thing I gave to both Mr. Asadi and Mr. Lechstein, I don't know if I've had a chance to necessarily look at it, but it's really a fairly simple concept. This is a Supreme Court decision. It was issued in 2004. The case is called Bubis, B-U-B-I-S, versus Casson. And it took place over here in Lock Arbor, not far from where you are right now. And it was a situation where under the Lock Arbor ordinance, there was a limitation on the height of fences to 6 feet or less. So the owners of this property at issue went ahead and installed a berm. And on top of the berm, they put high trees. So what
Can
they...
I interfere just for a second? I have a question for Mr. Lexstein. I was the planner of record for Ms. Bubis on that application that went to the Supreme Court, and they referenced me at my testimony as part of their decision. I don't know if that's a conflict on my part.
I don't think it's a conflict.
Yeah, I don't either, but I wanted to get that on the record.
No, I think it's an interesting, and I'll say the attorney who won that case, Glenn Needle, was my father's law partner in an earlier life. So it's a very, very small universe.
I will also say that the holding of the case matches what Mr. Higgins has said in his current planning report regarding our application. I'll get to that in a moment. But in the Bubis case, they put this berm out there. It wasn't a fence, it was a berm. And they put trees on top of the berm. So rather than having a 6-foot barrier, it was actually 18 feet. And needless to say, some of the adjoining homeowners were upset about that. And the issue was, did the ordinance barring a fence apply to this 18-foot berm, because a berm is not a fence? And what the Supreme Court said was, We have to look at the function. We have to look at the actuality. We have to look at the practicality. And whatever they did there, it may not be within the definition of a fence, but the function is exactly what a fence does. And because you're 18 feet up in the air rather than 6 feet, that doesn't fly. You're prohibited under the zoning ordinance from having an 18-foot berm with trees on it under the 6-foot limitation of a fence. Now, how does that apply to what we're talking about? The principle that the Supreme Court is talking about is actuality, functionality, and how things really are working on a given site. And at our site, there is no front yard orientation to Jerome Avenue. There's no possibility of us using Jerome Avenue as something that's adjacent to our property. We have no frontage either for lot 26, certainly nothing there, but not even for lot 44, because the improved portion, the paved portion of Jerome Avenue stops before our lot line of lot 44. So under those circumstances, I think the facts don't show the definition of a through lot under our zoning ordinance, land use ordinance. We don't have a situation where a lot flows through from Lewis Street all the way to Jerome Avenue. What we have is Jerome Avenue situated in a position that may be close to our property, but doesn't give us any functional frontage on it. So on that basis, I would contend that, in fact, we're not a through lot, and we don't need a front yard variance, although I did notice for it, just to give the board the jurisdiction on the issue.
Question, any of the cases cited in the Supreme Court case?
Yes.
Do you know if any of them deal with anything other than fences? Did you look at
In other words, in the case,
Yeah,
this
in
case,
that Supreme Court case.
It-
So I'm sure it cites other authorities. Those, may I see that? Do you
yeah, of
mind?
course.
I'm just wondering, my biggest question is in the code itself,
It talks about some other issues.
does it discuss functionality in the notes? Does it refer to functionality? Or, if these all deal with fences, I'm not sure how to translate that to this matter when we're looking at a pass-through, and if functionality is really applicable, if none of the cases discuss anything other than fences.
I think basically what that case is saying, and I didn't get a chance to reread it in detail, is that basically the berm was functioning as a fence. And that's why, and Mr. Donna, you've read it far
Right.
more intently than I have recently. And that's essentially what they said, is that the intent, you have to go to the intent of the ordinance. And in this case, they didn't define the berm as being the berm, and it was acting as a fence. It just wasn't what we traditionally think of as a fence. And the Supreme Court ruled, it's a berm pretending to be a fence, so therefore we're going to apply the fence code. And that's essentially what the case stands for. I don't know that that's necessarily what's happening here, but
That's what I'm trying
yeah.
to understand, if any of the cases cited by the Supreme Court perhaps addressed pass-through streets or,
I don't believe they do.
And in the notes for our code, does it discuss functionality as an element of defining a pass-through street?
No, but I wanted to point out one additional thing in Mr. Higgins' report as the planner for the board. He does say at page 4, at the top of page 4 of his most recent report, March 18, 2026, it should be noted that the front yard setbacks of the pool surround and pool are technicalities, since they abut the unimproved portion of Jerome Avenue and do not function as a front yard.
So Mr. Higgins knows, and I say this
Yes,
every
yes.
single time, there is no such thing as a technical variance. It either is a variance or it's not a variance. Mr. Higgins likes to say technical. It drives me nuts, and I yell at him every single meeting. But I am pretty consistent on that, and the board's heard me say that. There's no such thing as a technical variance.
Yeah,
It
and
either is a variance or it's not.
And I wasn't saying that there was not a variance required. I was saying that it wasn't abutting an improved portion of the street. And I think the important thing here is that the definition of a street in the municipal land use law and also in the ordinance says it's whether improved or unimproved.
Right. And that's my issue, that
Yeah.
whether or not it's an improved piece of Jerome Avenue, it still passes through. I don't understand, or I don't see where it is applicable that functionality is an element of a pass-through street?
Well, it becomes applicable under the Supreme Court
You make a
case.
good argument.
It,
I'm not gonna lie.
But as a matter of law, not at all to be in any way stepping away from Ms. Lippman's point, the law does get shaped by what we call the common law, what the courts rule. We don't have a higher ruling in common law in the state than the Supreme Court of New Jersey. The Supreme Court of New Jersey says we should look at our ordinances and consider practicality,
Do you have any case law
functionality.
about pass-through streets? Did you look at that?
Look at what, ma'am, I'm
Do
sorry.
you, do you have any case law with you
Yes.
about pass-through? Did you do any research on that?
Well, I didn't have a case on that because I thought that the Supreme Court case is about as good as you can get, but I do have the definition of a through street.
So I'm just wondering if I, looked it up right now on Lexis, and it would show that pass-through streets are pass-through streets regardless of functionality. Like, I'm just wondering if that has been the holding of courts with regard to pass-through.
so let me just, Mr. Donner, if I can, I just want to point out, because I think this is important to the decision, and Mr. Asadi still is going to have to speak.
Yeah, I was going to ask the process here just before you go.
Yeah,
Like,
and-
should we stop asking, I'm going to let you talk. Should we hold on questions until we hear what Mr. Asadi has to say?
I mean, I
Or
don't
you wanna
mind if you
go-
ask questions, but that's up to you, Mr.
Yeah,
Chairman. I would just point out that the case starts off, more or less, pointing out that the zoning ordinance in this town, which was where? It was Lock Arbor, didn't define what fence was. So the Supreme Court, therefore, was stuck having to say what I said before. We're going to go to what the common definition of a fence is, and this berm is acting as what we understand a fence to be. That's different than what we have here in Ocean Township because we specifically define what a street is. We specifically define what a through lot is. So I'm not sure this case is completely applicable because it doesn't meet the same facts.
Well, the definition, as I said, says a through lot is a lot that flows from one street to another, okay? Now, understand that's the definition. What do you do with what the Supreme Court has said? That when you look at your definitions, you should consider the practicality and functionality. There is no other Supreme Court decision that takes away or changes the meaning of what I just gave you. And there's no other court in the state that has the ability to reverse the Supreme Court. So what I'm going to suggest respectfully to this board is that the Supreme Court has added law to the interpretation of your land use ordinance. And in cases like this, you should consider, doesn't mean you're bound, but you should consider the practicality and functionality and what is actually happening. There's no way that my client is going to be able to utilize Jerome Avenue. There's no way that my client has a front yard that's oriented to Jerome Avenue.
But wouldn't that mean then, I'm sorry, Jim, go ahead.
The question I have is you have an unimproved street,
Right.
a section of it. Who's to say it's not going to be improved in the future? What you're saying is it's never going to be improved. And it could be improved right up to the very end of the right of way.
Well, I think we have to deal with the facts on the ground right now. A lot of things can happen, changes can happen on any piece of property and any adjoining street in the township.
But Mr. Donner,
But we make decisions on what's existing in the application.
I just think the issue with regard to the definition was so salient here because we have a municipal ordinance and our code, our regulations also define what a pass-through street is. Unlike your Supreme Court case where they were seeking a definition. This is probably one of the reasons it went all the way up to the Supreme Court. I just don't see how the facts are so distinguished here. I don't see how this is applicable.
And I would just, Mr. Donner, by that logic that you're advocating, like a paper street, would you not make any setbacks because it's a paper street that isn't likely to be developed at any point in time?
Well, if I need the variance because it's deemed to be a through lot, I made an application for it.
I'm not disputing that, you did.
I do need it, but I certainly, if the board disagrees with me on that point, obviously I'm going to be applying for it.
I'm just asking you to follow your logic. If there was a paper street, do not the setbacks apply to a paper street? It's not something you can access. You can't drive down a paper street But we routinely, in this board and every other board I represent, we always apply the setbacks to a paper street.
Well, under the Supreme Court case, I would answer your question, no, because the practicality and the actuality would disprove that approach. However, even if that paper street gets extended, and it's only, the extent of it is only a few feet, okay? It only comes maybe just adjacent to lot 44, it doesn't touch lot 26 at all. With what we're proposing now, in terms of the pool and the area that we're gonna have there, and the walls and the retaining walls, they could put the street right on through, as far as it can go. We're not gonna use it, we're not gonna be oriented to it as a front yard.
Speaking of the pool, how are you gonna put the pool in front using Jerome Avenue?
How, put it where with what?
The pool, how are you gonna put the pool in?
I don't understand the question.
I would say, how are you gonna dig the pool out? The only way to do it is using Jerome Avenue.
He's asking, how are you going to install the pool and access it?
I walked that lot, it's only.
It's 35 feet wide. It's 35 feet wide.
Unless you're gonna take it out in sandbags.
I haven't addressed that. My engineer may have an answer to that, and my architect may have an answer. I think there is space around the existing building to construct. There's, I think, over 9 feet on one side yard.
So if I can just make a recommendation that we hold off on that type of question.
Yeah.
now,
I'd like to hear from Mr. Asadi, if we could. And then Mr. Donner will come back with any further questions and then figure out our next steps. Nicole, could you give him a microphone? Good evening.
Good evening. Hope I'm not talking too close into the mic. Yeah, sorry about that. So, whether...
I think we need
Kevin, why don't you
introduction.
make your appearance?
Oh, I'm sorry. Kevin Sadi on behalf of Jay Stolman. Jay Stolman lives at 400 Jerome Avenue, which is adjacent to Lot 44. Sorry?
Is it right side, left side? I'm just curious.
If you're standing on Jerome Avenue, Lot 44 would be sort of to the right.
Can you kind of show us where, I'm sure it's not exactly on there, but if you can more or less show us where it is.
So he would be this lot right here.
Okay.
I think he's up a little higher, actually.
Is it?
Yeah. I think our engineering will back me up. That he would be across Jerome Avenue over here. Okay, he's not.
Oh, no, he's adjacent. He's adjacent. I've stood there and looked at it.
I don't believe he is. He's on the other side of Jerome Avenue.
We happen to have somebody here,
What was the address?
400 Jerome.
Yeah, it's lot 43.
43, that is that one, adjacent lot.
It's right here.
Yeah,
It's not included. Lot 42, not 40.
it's adjacent.
Okay.
Right, so we'll establish for the record that it's the same.
It was the wrong lot. I thought he was right over here.
Got it.
The lot he has is adjacent.
So I've never heard of this proposition before that for it to front on a street, the pavement has to actually be paved all the way up to the property line. No, we all know that that's not true. Okay. And as far as functionality, does this function as a front yard? It doesn't matter. The site itself, if you look at the plot plan, at least in prior editions, I'm not sure if tonight's version of it has this, but there's a gate from the pool area that opens up into Jerome Avenue. Now, how can you simultaneously argue that the frontage on Jerome Avenue is insignificant and technical and not functional and shouldn't be regarded by the board if we're actually using it to exit our backyard onto the public right-of-way of Jerome Avenue? This means if we're having a party in the back, maybe the guests should come and park on Jerome Avenue and walk through the gate. This means people that want to walk from Lewis onto Jerome, if they have permission, could cut right through. It's a public right-of-way. So to say it's not a through street, it just makes no sense. Now, Ms. Littman, Mr. Leckstein stole a lot of my thunder, so I'm not going to repeat the points that you've already made. But there is a point on the Bubis case that has not been mentioned, although it's been touched on. And while in the Bubis case, the word fence wasn't a defined term in the ordinance, and that's why the courts had to figure out what they mean by fence, right? Here it's defined. And when a term is defined, Bubis says, where statutory language is clear, courts should give it effect unless it is evident that the legislature did not intend such meaning. So here we have a situation where you have a defined term, the language couldn't be more clear. The situation on the surveys, the application materials, the tax map, that couldn't be more clear. The intention to use Jerome Ave as a right-of-way by virtue of the pool gate couldn't be more clear. This is a through lot. There's no doubt about it. And, I'm not going to belabor it. I think I heard a lot of the same points made that I was going to raise, so I'm not going to repeat those points. But I think it's very clear that the board should find this is a through lot.
Can we just get the definition, someone say it, just precisely what is the definition of through lot under our ordinance?
Yeah, I can get it for you in a second.
Any of your letter, if I can
That's right.
have your case. I don't know if I printed your letter out.
Through lot shall mean a lot running through from one street to another. A corner lot shall not be considered a through lot. And just for the board's edification, it defines a corner lot as a lot that's at two or more intersecting streets. Clearly, Jerome and Lewis don't intersect. So it's a through lot. And also in the definition of street, it says there's a catch-all at the end that there's like 4 different categories that can be a street. And then at the end, it says, and that a street shall be improved or unimproved.
So Jim, in your opinion, this is a through lot?
Yeah, it's a through lot.
Does anyone have questions?
I'll take yes for an answer.
Yeah, I was going to say, does anybody have questions for Mr. Asadi?
Kevin, where does it say, Mr. Asadi, sorry, where does it say in the case that you're referencing that, the piece I just read? In what section of it? Do you know?
I only just got the case, I only just saw it at 6 o'clock, but I read it on my phone. I could probably locate that for you pretty quickly. If you have the head notes, it's one of the first head notes. I think it's head note number 2.
It's in Chapter 2, and it's a second head note. And let me just see where the second head note is. Head note 2. But it does say, head note 2 is where statutory language is clear, courts should give it effect unless it is evident the legislature did not intend such meaning. Moreover, statutory provisions should be given their literal significance unless it is clear from the text and purpose of the statute that such meaning was not intended. So that's the second head note of the case. I'm just having trouble finding that within the case itself. But I have no doubt that it's in here. Well, it's ultimately up to the board. I tend to agree with Jim and Ms. Littman. Oh, here it is. I found it. And the case says, I'll read it right now. In determining whether the fence violates the ordinance, we must adhere to the principles of statutory construction. Where statutory language is clear, courts should give it effect unless it is evident the legislature did not intend such meaning. That's the Rumson Estates Inc. versus Mayor of Fairhaven case. Moreover, statutory provisions should give their literal significance unless it is clear from the text and purpose of the statute that such meaning was not intended. Yes.
And as far as, and I'll just add to this, as far as the intention of the legislature, the people on Jerome Ave are going to be looking at somebody's swimming pool that's adjacent to their own front yards. You pull up your driveway, and instead of seeing your neighbor's front yard, you see a swimming pool and swimming pool area, accessories. This is exactly the kind of thing that this through lot ordinance is trying to prevent, not cars coming in from both sides, but having someone's backyard in someone else's front yard. And that's what we have here.
Okay.
It's up to the board. I mean, the board.
Yeah,
the board is the ultimate
so
fire.
we've.
I have something to say. I want to make it very easy for this board. I have no intention to litigate with Mr. Asadi in the appellate division. I already have a case in the appellate division. What I want to do is withdraw that situation, that exemption from the through lot, and I want the board to consider affirmatively granting me the variance for the front yard in this matter. And I will also say that that gate is going to be eliminated. There's not going to be any gate. There happens to be a line on a plan right now. We're removing that gate. That's number two. Number three, no one's going to see this pool because one of the variances that Mr. Higgins has asked us to get, or at least mentioned to the board, is that we have a fence and then another wall adjacent to it. So there's going to be 6.3 feet of barrier between the pool and anything beyond the borderline of lot 44. So that pool will not be in anybody's face, and that's not our intention.
Withdrawing the application for the pass-through then, we are saying then that this is a pass-through street?
I'm not litigating that issue that it
I'm
is
not
or is
asking you,
not.
I'm just wondering.
Yeah, he's asking for the variance.
How it affects the other case, how it affects the case overall.
Well,
What is the impact?
the impact, as I understand it, is that I would need a front yard variance for the portion of the property, lot 44, as it borders on Jerome Avenue.
Thank you.
And so we're basically talking about Jerome Avenue is not squarely faced with the back part of our lot 44. It's really off to the side.
Yep.
It's the side of lot 44.
You'd need a variance on the fence, but that's frontage on Jerome.
You also need the variance for the swimming pool in the front yard.
It would be the swimming pool to surround the fence. I'm asking for that variance.
So I'm just gonna point out, because now I'm thinking about it, and Mr. Donner, I'll leave it to you, but the notice that was, you didn't notice for a variance for a pool in the front yard. You noticed for the setback in a front yard. So I'm just pointing that out, how you want to proceed with that.
I most definitely noticed for side yard setback and rear yard setback.
You did?
On the accessory features, including the pool.
Yes.
And I do have the catch-all in my notice, so looking for any additional variance that I might need in the course of the hearing. I already covered accessory items and side yard and rear yard setbacks, so I would probably be within the catch-all phrase that the public has had adequate notice.
And I'm not necessarily saying it's fatal, but I just wanted to bring it to your attention that was not noticed. The actual prohibition against pools in the front yard is not in your notice. So again, I'm not going to say it's fatal. I just wanted to put it on the record for you to be aware of it. Because you do have an objector to this application.
Okay, I understand. I've noticed as much as I can. And if I have to fight them, I'll have to fight them. For what other people before, that's what I do for a living.
Mr. Asadi, do you have any comments or before we go into the heart of the application? Yes, please. So we make sure we get you.
I could probably speak from here.
I'm sorry.
I think if this issue were clear from the very start, this is the kind of thing that would be in a notice, a swimming pool in a front yard area. My client's here, so he's not been deprived of fair notice. I don't know who else resides on Jerome Avenue that might take exception to a swimming pool in the front yard area, but nobody that I represent currently.
Okay.
Mark, it's fair to say we're not going to complete this tonight.
What are we at?
We're at a half hour.
We're at a half hour now.
So I imagine,
So, Mr. Donner, we have a 45-minute limitation for all applications.
Well, I saw that Mr. Akins only took about 30. That gives me.
I'll give you those 10 minutes.
Fair play, another 10 minutes or so, since I was such a good sport.
I will give you those 10 minutes, but I highly doubt we're going to finish this evening.
20 minutes.
So I imagine you'll have to notice, and then when you notice, then there'll be, for all these things that, right, pool in the front yard setback and all that stuff. And so the issue of notice will kind of take care of itself.
I'm disputing that I need a separate notice on that.
Okay.
I want to go forward.
Okay, well, we can talk about that.
You know what? I just want to confer with my client about that. Can I
Okay.
have 30 seconds?
Yeah, sure, certainly.
I think it'd be important for us to understand what all the variances are gonna be.
Yeah. They are going to have to come back with a whole new list.
Yeah. And which condition we notice.
The engineer's
testimony is worth about 7 months variance. Just to go through it all over.
It's Letty. I was someplace the other night.
I mean, if it was one, they want
Very.
I don't even know, like, what's the front yard? Is it just this, or is it this whole?
No, it would be the two short pieces.
It's just these two short
That
pieces.
one going north-south on the plan, which is still a side yard.
This
That's a
is
side
still a
yard
side
for
yard.
side
So
lot.
this is 3 front yards? So you have three. Yeah. So theoretically, from this
I
corner.
think I'm going for the record of the most adjournments on any one application. If that's so, I want an award. Going to adjourn because I see no reason to expose my client to a technical, excuse me, using the term, a technical objection on jurisdiction or whatever. We'll come in, we'll notice to the world everything, and hopefully in the next meeting in June, we'll present the entire application. And this time, Mr. Akins is going to have to fend for himself.
So I want to make sure out of fairness to everyone, this board ceases to exist after the June meeting because it's being consolidated into the planning board.
We'll start again.
Yeah, and that's, so I just wanted to make sure that was on the record, that you were aware of that. If we don't finish in June, I imagine what you would have to do is get the transcripts and give it to whatever the new board is that's going to be
You don't
appearing
have
after
to
that.
start all new exhibits and everything like that.
I don't know, I'm gonna have to think about that. I don't know, but we'll talk about it. But hopefully we will finish in
If
June.
we finish in June, we don't have that.
You don't have that problem if we finish in
Can
June.
you make sure that when you come back, all those new variances associated with this front yard setback
Yes, sir.
are listed then? Because
Yes, sir.
wanna make sure-
I don't want you to think we didn't list a lot of variances. I mean, I have.
He listed a lot of variants.
Oh, yeah.
Full of variances. I'm not adverse to listing
Yeah,
variances.
no, I just don't know what the new ones are
Yeah,
based off
well-
of this new requirement.
We're gonna rely on our experts to walk us through them. Yeah.
Everything else I believe is covered. But I will do my level best. Okay. Thank you. Thank you, board members.
All right, 1 second, Jeff, just 1 second. Hold on. Jeff?
Yes, I'll have the
Jim's
zoning
asking.
officer do the
Yeah.
review.
All right, so what's gonna happen, the conversation just happened on our side, I know there are multiple conversations, is Jim asked Colleen whether the zoning officer would issue a new letter based upon the establishment that this is a through lot, and the answer from Colleen was yes, she will. So there will be a new zoning officer letter to you so that you can basically work off of that. Okay,
And I will also amend
okay.
do an amended report listing those variances too. so.
May I have Martin his case back?
Yes.
I sort of.
By the way, for the board's edification, Ms. Bubis won the case and she lost the battle because she lost her house during Sandy, and if that berm had been there, she might not have lost her house.
See? Practicality and functionality.
All right, and, okay, so, I know there, all right, so, Mr. Chairman, I think there's a member of the audience, there's a member of the public who has an issue with that date. So I just want her, do you want to give her a chance just to be heard? I think out of fairness.
Yeah, we can do that.
Ma'am, you want to stand up and take the mic and just tell us who you are and what's going on? I just keep seeing your hand go up, so. You have to take the mic. And I might not let them answer the question, but it's going to depend. What is the date to call for the June meeting?
17th, so Wednesday.
June 17th.
Miss, if you could come over and just grab the microphone.
Identify yourself, please.
Dorothy Goodrich, 221 Lewis Street.
Thank you. Go ahead, Ms. Goodrich.
One of my questions was, if this isn't finished after the June meeting, when's the next meeting after? When do we get together again?
We don't know, as Colleen saying, but presumably it would be in July. It's just gonna be a different board. So, if we don't finish in June, and the intent will be to finish in June, if we don't finish in June, then there's gonna be a reorganization, which there would have been anyway at the July meeting.
That's what we're gonna find out what date that is.
Yes.
That meeting date is set. So
Okay.
that will happen. Whether it be business or just a reorg, I'm not.
Oh, I hear what you're saying, okay.
July 22nd is the planning board, oh, no, I'm sorry. July 27th is the planning board meeting for July.
Okay, thank you.
Thank you.
I'll just mention, I do have other objections, which...
So we can't go in, I'm not gonna like.
Right, I understand that.
An objection about the application.
I understand that. I will. But you just want me to talk about the fence in the back?
No, I don't.
Oh, you just wanted me to ask my question?
All we wanted to know was I thought you had an issue over the date.
No, it's fine. The next meeting's fine, and the July 27th meeting is fine. I was concerned if you had the July meeting earlier than planned. Okay. That's all I wanted to know. Thank you.
All right, so Mr. Chairman, we are carrying this application to the June 17th meeting in this room at 7 p.m. You will not, do you want to talk about notice? I mean, I don't, oh, you're going to give new notice. So he's going to give new, right, he's going to give new notice, so you're going to get the notice, but nevertheless, be here on June 17th in this room at 7 p.m., regardless of whether you get the notice or not.
So how soon does he have to be able to, you need the letter from the town to be able to do proper notice, right?
He has to do it within 10 days. I know time's growing very short. You might just, I don't know if it's going to be.
I think I know where the zoning officer is coming from. She did mention something to that effect in the existing letter.
Yep. You just want us to recognize that you're going to need that information quickly to be able to do that, right? Okay.
Proliferate notices, that's all.
All right, thank you, Mr. Donner.
Thank you. Appreciate it. Thank you, board members.
June 17th is a Wednesday.
Okay, our next case is Zachary and Gretchen Wilson, 1307 Edgewood Avenue, Block 127, Lot 17.
Thanks. See you later. Have a good night. Just gonna make sure. Give us the comments if there's no chance. Because I will walk off of it. I'll give it to Nicole. June 17th. No, that's the most important thing. That's proven notice.
Okay.
In your pajamas.
Mr. Wilson?
You ready?
How are you?
Good, how are you?
Just give me 1 moment. Mr. Wilson.
Sure.
I just want to make sure I get organized. I apologize. Zachary and Gretchen Wilson. All right, I'm going to mark in the following exhibits. Exhibit A1 will be the variance application itself. Exhibit A2 will be the survey. Exhibit A3 will be the architectural plan. Exhibit B1, as in Board 1, will be the zoning officer's report. Exhibit B2 will be the board planner's report. And Exhibit B3 will be the board engineer's report. And Mr. Wilson, let me just swear you in. The swearing testimony you're going to give this evening will be the truth, the whole truth, nothing but the truth, self God.
I do.
And just state your name for the record.
Zachary Wilson.
Hi, Mr. Wilson. You are under oath. Mr. Chairman, it's all yours.
Okay. Okay, Mr. Wilson, if you could explain to us what you're doing and your understanding of what variances you need, please.
Sure. We are adding a second-story addition to our split level on the left side, where there's a single level. We're going to do a porch upgrade. We're going to cover the porch, and we're going to relocate the porch steps to the front and the walkway to the front. The house is currently at a 23.5 foot setback, and the porch is 18.6. This all makes sense. And so with the change, the house will just be a little bigger with 24.9 setback, and then with the stairs in the front would be 13.6. Should I talk about the stairs?
Okay, so your stairs are going 5 feet closer?
Yeah, so right now the current stairs are on the side. They're very steep. They're dangerous. We have a lot of old people in our family. When bad weather, it's not a good situation. So for safety reasons is one of the reasons we want to move it to the front. We want more of a grade with the stairs, safer stairs, a little bit wider. And also with the plans of the covered porch, aesthetically, it looks much nicer. Our street, South Wanamass, if you're heading west, it's perpendicular to Edgewood, and we are the house you see when you walk west on that street, if you drive west on that street. So, aesthetically in the curb appeal, it'll look good for the neighborhood.
Okay. So it's just a front yard setback?
That's it.
Yeah.
Okay.
A little easier than the last one.
We can make it.
Oh, that's right.
Jim, you have any comments?
No, the only comment, I have a couple of comments about
Sure.
The architectural plans.
Sure.
What are the number of bedrooms?
Okay, so
Right
we
now.
currently have 4 bedrooms, and we are adding a bedroom, but taking away a
So
bedroom.
you're
So we're still
so
only going to have
bedrooms
4 bedrooms.
aren't increasing,
No.
so it doesn't affect the parking requirement.
Correct.
It's the same. And that there's a shed in the rear yard that's non-conforming. Should it ever be replaced, it should be put in a conforming location.
Okay.
Other than that, I don't have, I wanted to hear testimony as to why they were relocating the steps and making the setback smaller, but that makes sense if it's not a safe condition, and this is a safer and a much more aesthetically pleasing condition. I don't have a problem.
Yeah, you said in the past, steps usually are considered a worthy exemption, right, from the for variance. Mr. Matlick, do you have anything?
The only thing I had was, there's a garage that, with the garage door that opens to the back of the house.
Correct.
But there's no driveway that, leading up to the garage door. Is that,
We don't-
are you ever going to put in a driveway?
No, when we bought the house, the driveway went to the back, and it was half the backyard. We never used the garage, used it as like a workshop, stored bikes. And so we just got rid of the driveway in the back and put in sod for the kids to play.
Okay.
It'll never be a garage.
Okay.
Any questions for Mr. Wilson? Any questions for the public? Any comments from the public? All right, we'll close the public hearing. Can I get a motion?
I'll move the positive resolution.
I'll second.
Mr. Eskenazi?
Yes.
Mr. Shimura?
Yes.
Ms. Whitman? Yes. Mr. Fujielli?
Yes.
Mr. Lenasky?
Yes.
Vice Chairman DeGenaro?
Yes.
And Ms. Fuller?
Yes.
All right, thank you. Have a good night.
Just
Oh, you had
for the record-
professionals? We could have had him talk.
We gave
an off night.
You-
You guys never want to let the architect come.
You don't have to pay him if he doesn't talk.
I listen to him all day.
We have you, we don't need another.
All right, next we have Louis Victoria Hofstein, or Hofstein, 487 Stafford Street, West Allenhurst, Block 73, Lot 13.
Good evening, Jeffrey Beekman of Beekman Law Firm. I represent Louis and Victoria Hofstein. Property is 487 Stafford Street, West Allenhurst, and the block and lot is Block 73, Lot 13. While Mr. Bell's getting ready here, I'll just go over quickly what we're doing here as far as the...
Let me mark in.
Oh,
what
thank
I
you.
have. All right, so I have the following exhibits. Exhibit A1, it will be the variance application itself. Exhibit A2 will be the color photos of the existing landscaping. Exhibit A3 will be the fence specs. Exhibit A4 will be the survey of the property. Exhibit A5 will be the architectural plan. Exhibit A6 will be the plot grading plan. I then have the following board exhibits. Exhibit B1 will be the zoning officer's report. Exhibit B2 will be the board engineer's report. Exhibit B3 will be the board's planner's report. And Exhibit B4 will be the board's planner report with respect to the landscaping.
Yes. So quick overview, the applicant has a 2.5-story dwelling that is fronting 3 streets. So we are asking for variances for front yard setbacks as a result of the existing 3 streets. We are also asking for a slight building coverage, which will be explained what that is for, but in essence is about 80 square feet, the building coverage, and we're asking for 25.8% building coverage where 25% is permitted. In addition to that, we have a lot with 3 streets. We're asking for a variance for a front yard setback to the pool patio that's being proposed. The pool is fully compliant. The pool equipment will be compliant. Any additional equipment as far as mechanicals will also be compliant as far as the application goes. So this evening I have my clients here if there are any questions, but I also have Jeffrey Bell, our architect, who prepared the architectural plans and also worked with Charles Sermont to prepare the plot plan.
Okay. Sir, let me swear you in. Do you swear any testimony about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
And just state your name for the record.
It's Jeffrey Bell, B-E-L-L.
And you're a licensed architect, state of New Jersey?
Correct.
Are you a RA or AIA?
R.A.
All right. Thank you. And your license is in good standing?
Yes, sir.
Thank you very much.
So, Mr. Bell, if you could just explain what's being proposed here as far as the 2 front facades, particularly as we're talking about Stafford Street as well as Beechwood Avenue? And we're referring to sheet A2?
Yes.
Okay.
So this is the proposed front elevation, and this is the other front elevation. We're proposing squaring off the building. Essentially, there's corners missing from the bulk. When you're looking at this portion is set back currently, and when you're looking at this side, this portion here is also set back existing. So we're proposing to fill this in with 2-story and fill this part in with 2-story also.
And Jeff, if you want to just go back to the plot plan, and if you could just show the board from the plot plan, those areas that you just talked about as far as infill.
Sure, that would be this part here and this L-shaped piece here.
All right, and when we're talking about that L-shaped piece, there's actually a piece that's existing within that area, if you could just identify that.
That would be, it's shown here, but there's also a faint line that indicates that this is an existing single-story part of the structure.
And the plot plan is shown shaded in because you're proposing to go up in that area, is that accurate?
That's correct, here and here.
So if you just show that area that you were talking about.
This area and this L-shaped area here.
So as far as the setbacks concerned, are you going any closer to Stafford Street than the existing dwelling?
No, sir. The proposed is flush with the existing part of the house on Stafford Street.
And in addition to that, you're proposing a wraparound porch?
Correct. So there's an existing covered porch. We propose having it wrap around and go the length of the house to the rear, being equal to that existing single-story portion of the house.
And that covered porch, is there anything above it?
No.
Just roof?
Just roof. It's just a covered porch, and that's proposed to ease the massing of the house along with the roof structure to preserve the light, air, and open space to make it so it doesn't seem so large and that much of an addition. So make it blend in. And the hip roofs, the existing design is we're making it very similar, just a little bit taller.
Can we go back to sheet A2? So now that we have the facade plans again, can you just show on A2 where the wraparound porch is on both of those frontages?
So we would start here, where this is the existing part, and then the new part would be here, and then turn the corner and go down the length of the structure.
And in your opinion, as an architect, does that create any aesthetic value to the property?
It does. It creates a nice shaded space on the south-facing portion of the house, so it'll help with heat gain. It'll also makes the house, look a little nicer and it breaks up the facade. It makes it more interesting. So it's not like we're looking at the side of the building. The owners wanted to make an effort to have this side look appealing as well as the front when dealing with the multiple frontages.
And the fact that we have a lot with 3 streets, does that have any impact on the developability of this property?
Yes, the zoning laws make it difficult to fulfill any of the setbacks.
One of the variances that we're asking for is building coverage,
Correct.
right? Can you just explain how large square footage-wise what we're asking for?
I believe it's 80 square feet.
And the single-story wraparound porch, how large is that?
This part here,
Yeah, the entire wraparound porch, approximately how large is that area?
square footage wise or dimension?
Square footage.
It's not noted on here, but we have roughly 52 by 8 is the proposed size.
So somewhere in the neighborhood of 400 to 500 square feet?
Yes.
You said 52 by 8?
Roughly, yes.
And so the other thing we're asking for, and we'll go back to the plot plan. At the beginning of this project, you were involved with assisting the applicants preparing the plot plan, is that correct?
Correct.
And one of the things they were proposing to do is a pool.
Correct. Here.
And as far as the pool is concerned, location of the pool itself is in a compliant location as far as front yard and the rear yard setback?
Correct.
The patio to the south side, which is the right side,
Right here.
the other side.
This size.
Yes, that patio area that's being proposed, that's also conforming to the front yard setback at being at least 30 feet?
Correct.
And we're proposing a small setback deviation on the
This side.
left side, the north side. And what is that dimension?
15.5.
And we're proposing the patio to be 15.5 on that side, correct?
Correct. Which makes it align with the existing concrete patio. And it is also a more desirable space of the yard to be used for sunning and poolside.
And as far as that patio is concerned, the fact that this property has 3 streets, there's going to be some limitations on setbacks.
Correct.
If it were side yard setback, would we even have a variance?
No.
And the other question is, as far as the total impervious coverage, what we're proposing is completely compliant to impervious coverage, correct?
That's correct. Yep.
So if we just quickly reiterate the variances, we're looking for 2 variances on the Beechwood side, correct?
Yes.
And one of those variances is the setback to the structure, the actual
Yep.
living area,
That's here. Yep.
right? And what's that distance?
15 plus 8, it's 23.3 feet.
Right. And that's the same as what's existing as well?
It's in line with the existing frame.
And then the porch setback, what is the proposed single-story porch setback?
15 feet.
And in the front yard of Stafford Street, again, what's the variance we're proposing?
It's 20.8 feet,
And
which
that's-
is in line with the existing building.
And there's an existing single-story covered porch as well?
Correct.
And what's the depth of that, or the setback of that?
It's 20.8 feet. Actually, no, sorry, that's 13.1 feet to that.
13.1, and again, we're not going any closer to the Stafford Street.
Correct.
setback, correct?
Yeah, and the intention was to have the porch corner be curved, so we're maintaining the same distance, so with the geometry of the building, it makes a nice turn, and when it makes its way down to Beechwood Avenue.
And what's the depth of the porch?
I think it was around 8 feet, roughly
And is
8 feet.
As an architect, is that a pretty standard depth porch?
It makes it usable. Smaller than that, it's tough to furnish. Things get tight. So 8 feet is good enough for a small table with walk-through, with pass-through.
All right. Thank you. I have no other questions.
Any questions? No questions. Any questions? Any questions from the audience? Come on up.
So these are questions, we're going to try to limit these questions to the testimony of the architect. How many witnesses, Mr. Beekman, do you have?
I only have the architect.
You only have the
here,
architect,
yes.
all right, so then I
Yes.
guess the free-for-all. Ma'am, do you just swear that any testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
And just state your name, spell your last name for the record, please.
Melanie Nolan, Nowlin.
Nowlin?
Yeah.
And it's Melanie?
Mm-hmm.
And what's your address?
I own property at 605 Laurel Avenue.
Laurel Avenue. Okay. Is that anywhere near this property?
It's right around the corner.
It's around the corner, okay. But it's not immediately adjacent, but it's around the corner?
No.
Okay,
No.
thank you.
I just have a question about impermeable coverage. How much is allowed? Because you're going to have a pool, and a patio around the pool. That all adds to impermeable coverage. And since we are in a flood zone, coverage is very important in that area.
Why don't you just indicate what the coverage is allowed and what the coverage is proposed?
So total coverage,
Yes, total coverage.
we have, existing is 3,150 square feet, and the proposed is 4,050 square feet.
So what is
And the
the
maximum is
percentage?
6,500, so they're way under.
So that's 40.5%.
That's right. They're permitted 60%.
The maximum is how much?
65%, they're proposing 40.5.
So Ocean 65%
Yes.
coverage.
Yep.
Okay,
It's all here if you want to take a look.
fine. I just did not know what the coverage limit for Ocean was. I'm kind of surprised that it's that much since we're, blocked from the lake.
It's different in different zones, but in this zone, it's 65%.
All right, sir, we're going to do the same thing. Do you swear any testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes. Gene Tate.
I'm sorry?
Gene Tate.
Yeah, maybe come over here.
Gene Tate.
And spell the last name, please?
Taetschch.
T-A-T-C-H?
SCH.
S-C-H, okay. And your address?
604 Laurel Avenue.
Okay, thank you.
Question I have is, originally when this house was sold, the MLS listing stated that there was environmental damage, and I don't know if it was ever remediated with the soil. Has any soil tests been performed on this area?
I would just say that's not part of this testimony. I don't know that an architect can answer that
Yeah,
question.
I don't know if that's relevant to this application. If they had to do remediation with the DEP, they had to do remediation with the DEP, but it's not relevant to a land use application of this nature.
Not even if they're setting it up for a pool?
They're going to have to do the appropriate permitting that they're going to have to get.
Okay.
So they wouldn't have been able to close on the house unless they remediated the property first. And they needed a letter from the DEP stating that it's complete.
So a letter is available for that? To state that?
Open Public Records Act, it might be a matter of a public record or.
Through the DEP, yes.
DEP,
They can go
okay,
through the
okay.
DEP.
And on the site, it's called Open, OPRA. You can just make an application for it.
Okay.
They wouldn't have been allowed to close.
Okay. One other question I had was, the front setback on to Staffa with the existing structure and the additional porch is only going to be 13 feet? Is that correct?
Stafford Street, yes, 13.1 exists to their existing covered porch, and then we're coming from that corner and wrapping it down Beechwood Avenue.
And the setback on Beechwood Avenue will be with porch.
It will be 15 feet from the property line to the proposed.
And what is it now? Is it,
Right now, it's 23.3 from the property line to the building.
so it's almost 8 feet difference?
Yeah, yeah.
Okay. Now, is there going to be fences required because of the pool? That's going to be part of that setback issue?
Yeah, the pool does require a pool compliant fence.
So does that make the setback even less?
No, the fence has nothing to do with the front yard setback. We're proposing I believe we're proposing a fence in a compliant location, but perhaps Mr. Higgins, or Mr. Matlock can chime in. I believe it's conforming where we're proposing it.
Would be, if it's in the front yard, it has to be maximum 4 feet high and
Right.
tilted. And on the side yard, it could be 6 feet high.
So, but the fence,
No variance being requested.
That's
but
right.
the fence for the pool, is that going to, how does that play with the setback in the front yard? With the fence going there around,
Fence does not have to comply with the front yard setback. As
Okay.
long as the fence is 4 feet high or lower and can be seen through, then it can be right up on the front property line.
And Mr. Tesh, if I may, Jeff, if you could just point out where that proposed addition is on Staffa?
Here.
The front, yeah, to the left of that shows the fence. That area right there, if you can see that.
and do we have locations where garbage containers are gonna be stored? So they're not out on the street?
Garbage?
No, that's not sure.
I mean, we don't, yeah, this is a single-family residential lot. We don't show garbage can locations.
Okay, so the garbage can be anywhere other than, it doesn't have to go on a plan at all.
It's property maintenance.
Okay. And is there, how many trees are going to be removed from the pool?
You know, I can have my client come up and answer that question. Yeah.
But they're gonna have to comply with the tree ordinance, tree preservation ordinance of the
Right.
township.
That's right.
Thank you very much.
So what you're asking for is a clearance letter from the DEP.
Thank you very much.
Was there an answer to how many trees are going to be removed?
So, come up, Louis. You're gonna have to be sworn in now.
If you swear any testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
And just state your name for the record.
Louis Hofstein.
And you are the applicant in this matter, correct?
Correct.
Thank you.
So, Louis, in your backyard where the pool's located on that plot plan, are there any trees in that area?
No.
The only trees in your backyard are along the property line, correct?
Correct. There's trees in the front over here, like on the side of the house over here. But where the pool is going, there's no trees over here. There's only bushes around the house.
Okay, and you're not proposing any changes in those bushes?
No.
And we provided as part of the application photos that you took showing those bushes, correct?
Correct.
So there are no trees being removed as part of this application?
For the pool?
For the pool area?
For the pool?
area. No, there's no trees whatsoever on this side.
Well, how many trees are actually being removed to do the project?
There possibly be one tree that's over here that we're thinking about that's already not okay, because last year it fell down, 2 years ago it fell down on the power line, and last year it fell down on my house, part of my house.
But you think at the end of the day, there's only one tree that's going to be removed?
Most likely one tree.
Okay. Is there a potential for two? I just don't want.
Possibly, saying, yeah.
I don't want you to
Correct.
say one tree and then suddenly there are two and someone's screaming that you took down two.
I know that there's one tree for sure. There may be another tree depending on how, but we will be adding new trees if we take anything down.
So you think the maximum would be two?
Correct.
Okay.
And Mr. Lechstein, obviously, any resolution of approval could indicate that the applicant must comply with the tree
100%,
preservation
yes.
plan.
Thank you.
Any more questions?
And then when we
Thank you.
swear you in, do you
And if you
swear
could come over here, it's away the feedback.
Get away from all the feedback.
you swear your testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Can I just state your name for the record?
Yeah, Patty Kronheim, and I live at 486 Staffa, so I live right across the street. And I just have a couple.
Could you please spell your last name?
Cronheim.
And I'm sorry, your address again?
486 Staffa,
Thank you.
which is directly across the street. And I also have a three-sided property, so I understand the limitations and everything with that. I just have some questions. Right now, the house had a big addition a few years ago, so like the whole part that they're going to bring forward was an addition to the house to begin with. But I'm wondering, does the porch go, it's hard to tell from these pictures, is the porch going to go all the way across, or is it just going to stop where it already does in the front?
No, so on this side where the existing porch is going to remain as it is.
So it's going to end?
It's going to remain where it is as it is. No changes to the expansion of that front porch. The expansion is proposed only to the Beechwood Avenue side.
So it's curving around here. And so this is going to just be one wall now going up 2 stories.
This is a two-story wall. Half of it has a covered porch roof on it. So it'll look something like this. So this is it now.
Uh-huh.
The setback.
And this is set back how many feet now from the building?
It's about, let me see, about 8 feet.
Uh-huh.
From the existing front corner to where it sits today.
Mm-hmm.
And the proposed is to make it flush with the wall.
So it's going to look like this.
So it'll look similar to how it looks today. The roof geometry stays the same.
So it's going to be a different roof here. Well, it's not going to look the same. It's going to look like
It's the same roof, but this is forward now, proud, yes.
Proud, okay.
Equal,
That's
equal, sorry.
right, okay, so it's going to be so where it was set back and there was no air and light, it's going to be more forward now,
Correct.
up to the front.
Equal to the front, yes.
Okay, and the tree, by the way, I just want to say that tree did have a branch that came down, but that's like a 100-year-old gum tree, and I know those trees, people don't like them because of the gumballs, but it's a beautiful tree. I love sitting on my porch and looking at that tree, and I understand gum trees are difficult. I have to sweep all them up too, they come on my yard too, but it is a beautiful old tree. I'm on the Shade Tree Commission, and I know they have the right to take down what they want, but that's a real loss, and I would hope that if they are going to take that down, that they're going to put a sizable tree up, not just like a crepe myrtle or something, but actually a beautiful tree, because we're trying to have, it goes over the street. It's one of the largest, prettiest trees in the neighborhood, in this old historic type neighborhood, and it would be and now it blocks, it sort of provides coverage and blocks like having, just structures. So we want to keep the character. It's just would be nice to have that be there. But and I'm concerned about flooding, because we all flood, and I got 3 sump pumps that go constantly. But those are my concerns. It's just light, air, space, tree, flooding. But I understand wanting more space, but I wish it was a little more elegant, where it's set back a little bit, so it was just a little more interesting. But I understand design is not something you guys can weigh on. But that's just my thoughts. Thank you.
Thank you. Any more questions? Yeah.
Okay. All right, ma'am, you're still under oath. Just repeat your name for the record.
Melanie Nolan.
You're still under oath. Go.
Yes. Just a comment about the trees. Ocean is taking down an incredible amount of trees. Every time I turn around, there's trees down. And people don't seem to understand that a new tree does not do the same thing that an old-growth tree does. An old-growth tree holds water in the ground. Since we live in a flood area, that's an extremely important thing. For some reason, people don't want to understand. But when your house is being pumped out, you're sloshing around, then you start to understand. Old-growth trees are very different. They're not like arborvitae or any of the other things that are put in. or a new tree?
Thank you. Okay, Mr. Higgins, I didn't ask you about your report. Is there anything that you wanted to mention?
No, I think they basically they were very cooperative. They had changed a number of things that we had comments about. And it's a very difficult site with the three frontages. So I think they've done a fairly good job.
Okay. Mr. Matlack, did you have anything?
My original report had a list of comments, and the plans were revised, and they addressed all the comments. I do want to clarify something. There was mention about this property being in a flood zone. According to the FEMA flood maps, this property is not in the flood hazard area. So I just want to clarify that for the board.
Okay. But high water table probably, certainly,
Yes,
right?
certainly.
Just
You're-
like
you're
a lot of us do.
surrounded by deal lake.
Yeah.
So
Yep.
it's
Some pumps going all day long and stuff. Yeah.
Sure.
Okay. Any questions? Last chance? Okay. Close the public hearing. Do we have a motion for approval? I'll second.
Mr. Ashkenazi?
Yes.
Mr. Chimara?
Yes.
Ms. Whitman? Yes. Mr. Fujiali?
Yes.
Mr. Lineski?
Yes.
Vice Chairman Casero?
Yes.
Chairman Pollak?
Yes.
Thank you.
Thank you very much. Good luck. Okay, lastly, we have Raquel Laniado. Apologize if I mispronounced that name. 9 Shadow Lawn Drive, Block 25, Lot 41 in the R2 zone.
I didn't see many changes. I looked at them today. I mean, it came in the day before I left.
Good evening. You ready?
Yeah.
You good? Okay. Ms. Laniado, is that,
Yes.
you pronounce that correctly?
Yeah.
Okay. Mark, are you ready?
We just need one moment.
Based on that.
I thank you, Mr. Chairman, for that indulgence. All right, so I'm going to mark in the following exhibits. Exhibit A1 is the variance application. Exhibit A2 will be the freshwater wetland delineation field study. Exhibit A3 will be the recorded retaining wall easement. Exhibit A4 will be the topographic survey. Exhibit A5 will be the architectural plan. Exhibit A6 will be the addition pool and patio variance control plan. Then I have the following board exhibits. Exhibit B1 will be the zoning officer's report. Exhibit B2 will be the board planner's report. Exhibit B3 will be the board engineer's report. So let me just swear you in, sir, or who am I swearing in? You're not Raquel, obviously.
I'm not Raquel, no.
You're Raquel?
Hope he's not Raquel.
Okay.
I'm Raquel.
Do you swear your testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and just state your name for the record,
Raquel Laniado?
and you're the property owner.
Yes.
Thank you.
Okay, Ms. Laniado, you can tell us briefly why you're here. You can introduce who's with you. Will he be testifying? We can swear him in right away as well.
Okay, thank you. My husband Moshe Laniado is here, and He will tell you exactly why we're here.
Is it on you?
All
Okay.
right, sir, do you swear testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
And just state your name for the record.
Moshe, Moshe, last name Laniado, Laniado.
Okay, thank you. Are you a co-owner of the house?
I don't think my name is actually on the deed.
That's fine. I just wanted to make sure. Go ahead.
Okay, so if you could tell us what you're doing and to your understanding why, what variances you need in order to get done what you want to do.
Sure. We're proposing a second floor extension. I don't think we need a variance on that. I think the variance comes into play with extending our front or side yard to become part of our backyard and put a pool in that area. And that was due to some hardship due to a sewer easement that was there from a long time ago. And we have Tammy, an architect and engineer, right here behind me.
Okay.
If you have any specific questions.
Do you want to have the engineer, would it make sense? Give a brief overview of what's going on?
Yeah, sure.
I'm sorry, is it a hot tub or a pool?
I'm sorry? It's a pool that we plan to install?
Oh, existing, sorry, okay. That's okay.
All right, do you swear a testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Just state your name for the record.
Yes, Scott Lynn, spell Lynn, DS Engineering, Rocky Hill, New Jersey.
And you're a licensed engineer, state of New Jersey?
I am not a licensed engineer in the state of New Jersey. However, I have appeared before this board multiple times. I do have a degree in civil engineering from NJIT and about 38 years experience. And I hate saying that 38 years, but unfortunately, it's what it is.
I never know what to do with this.
I am a designer and I can provide testimony on behalf of the application.
But you can't give engineering testimony.
Correct.
Okay, so you're not going to give engineering testimony.
I am not.
You're going to give. Do you hold any certifications?
Yes, I do have an EIT, which is an engineering training that was obtained probably 35 years ago.
And that's a degree that's not. Is that from the state?
It is from the state.
And it's an EIT?
EIT, engineering training, which is a prerequisite for the PE.
And that's a license?
It's not a license. It entitles you to sit for the PE exam.
Okay, it's like a prerequisite to that?
Correct.
Okay. Yeah, I'm not familiar. I've never heard of that before.
The planners have a similar thing.
Oh, okay. You have to go through like something before you can go to sit?
Yes.
Okay.
You have to take it, 2 tests to become an engineer.
Okay.
First one is the EIT, then the PE.
All right. So as long as the board understands that he can't give testimony, his testimony, he's a layperson as far as actual engineering testimony is concerned. So the board, so that's why we have Bennett here, I guess. Okay, because you actually are licensed engineer. Okay. Go ahead, Mr. Lynn.
Okay. So.
Yeah, absolutely. Sure.
Absolutely.
Okay, so although the applicant did testify or gave testimony that there is no rear yard variances, we actually do have 2 variances associated with this application, which I will get to, but let me just go through exactly what it is we're here tonight for. If you look at this side of the plan, this is the existing house patio, no pool, and the existing driveway, which sort of meanders across the front, has 2 access on Shadow Lawn Drive. Although it's not a corner lot, it appears as though it could be a corner lot. It's a very irregular shaped lot in a very large radius. There is a front yard across the whole frontage, if you will, of Shadow Lawn, and this being the rear yard and this being a side yard. Currently, the house does not meet the rear yard setback requirements. It is short by about 2.5 feet. The rear yard requirement is 40 feet. We're at 37.5, but again, that's a pre-existing condition. We're not making that any worse. The front yard setbacks we do meet. However, we are proposing if I can get to this side, hopefully. can see better. We are proposing a second-story addition over the current first floor of the house with a small 71 square foot addition to the first floor. There is a proposed pool, which although is shown in the front yard, one can construe that that's more of a side yard. If you looked at the actual configuration of the house, by definition, it is the front yard. There is a variance associated with that, which is a 14.5-foot setback from the front right-of-way line, which is the property line.
There's also an 11-foot setback to the pool surround.
That is correct.
Not indicated on the plan, that's why I want to point it out.
That's correct, right. To the water line is 14.5 feet, plus the coping, plus a 3-foot sidewalk, which is along this area.
I'm sorry, Jim, there's an extra variance?
Well, that's, the setback is to the patio, and the chart on the plan says it's to the water. The setback should be to the patio.
Setback to patio,
11 feet.
11 feet, and,
Yes.
and what's required?
What's required is the front yard setback.
45 feet.
45 feet.
Okay. Okay, so that's an extra one, just to know for the record.
Correct. There is a, to the side, there is a rear yard variance that we are seeking as well. There is a roofed, I guess that's a covered terrace, which is proposed to be built on the back of the house. That also is going to require a rear yard setback. That setback is required as 40 feet, and we are proposing that roof structure to be at 26.4 feet. So those are the two variances associated with this application. We are planning to...
I just want to make sure
Certainly.
that just for the sake of the resolution, when we finally get to this.
Mhm.
So Jim's letter points out more than two variances, and I don't know, I understand it's changed. So the change of grade is no longer a variance?
So I wanted to talk about that when I got to the conditions in Jim's report and in Ben's report, but we can certainly talk about that now. Jim's report does mention the fact that we may need the township has, as you guys know, an ordinance that only requires a 2-foot change in grade. Right now, the intent of the pool and patio elevation was to be less than 2 feet. However, there's I call it an erroneous elevation and contour sort of right in this area that puts us slightly over the 2-foot requirement. So could that constitute a variance? Yes, but I have a feeling, Jim, with all due respect, that based on the as-built that the surveyor prepared, might have picked up some elevation that doesn't look to be correct. Based on, and I say that based on the existing contours, the way that they meander all through this portion of the property.
So that would have to be clarified.
Yeah, so one of two things. We can either seek the variance for the 2-foot change in grade, or if the board doesn't seem fit to do that, I can certainly revise the grading to thus eliminate that 2-foot differential.
Yeah.
Do you ever consider moving the pool where the proposed uncovered patio is? That is, your setback is so small compared to the
Yeah, so
it just,
the reason why we've done this, and we're going almost 2 years trying to figure this out, is there's a sewer easement.
Yeah, Mrs. Letman, I can get to. Yeah, I can get to that. Let me, if you can just continue.
patio?
Yeah. So why is the pool situated in this area? Currently, there is a 20-foot wide sanitary sewer easement which runs up the entire back of the property, leaving virtually no room for any improvements between that easement and the actual house. It's about 20 feet in width, so there's no room to put, and Jim does make mention of this in his report, that there really isn't any room in the rear yard for a pool or the side yard. This is really the only location.
The line of the sewer, which I know is so disrupted when you're trying to plan a home.
Mhm.
Couldn't you put the pool, for argument's sake, in front of the tree line where it doesn't? Or is just the digging that close to the sewer easement an issue?
Which tree line?
There seems to be trees along
The new one.
along the Shadow Lawn Drive proposed site plan.
She's looking at the new plan.
I'm looking at page 1, page 6.
One of my comments was they show trees or plants there, but there's no definition of what they are. They could be shrubs, they could be trees.
Okay, through, right here?
Not identified.
No. So it's easier.
Yeah, if I may.
Talking about the tree line behind the house.
There's a tree line
Okay,
right
that.
here behind.
Yeah, those are
And I
proposed
see
trees,
the
yeah.
sewer
Yes,
easement.
this is the sewer
And I'm
easement.
thinking, can't you just put the pool there, in front of that? Or is it too close to the sewer line? I don't know, because you're pretty close to
Yeah,
it too.
I understand exactly what you're saying. I think that would be a conversation with the homeowner. Sure. So where Mrs. Littman is referring to is not putting the pool here, but rather put the pool in this area.
Oh, we need space from the house.
But even if you put it 10 feet from the house, it still would be, and square it, right, make it parallel to the second floor, thank you, my builder. You still wouldn't be 14.5 feet from the required 45-foot setback, you would be over.
You're saying square it off to the house?
She's
saying turn it. Yeah, square it off the house and move it 10 feet from the house. So you're moving it 8 feet closer to the house.
Well,
But she's squaring it off.
I'm squaring it off to the second floor addition.
You're saying it make it, pull it back 8 feet into the property and turn it. Only the bottom right corner of the pool would be the closest point
This
to the
is why we
road.
had the builder on that. Thank you. Yeah, I'm a lawyer.
So by just doing a quick calculation, by doing what you're saying, moving the pool 10 foot off of the existing house, sort of in this area, it would reduce that front yard setback probably only by about 4 or 5 feet.
Just in the corner.
Just in the corner, correct.
But the rest of the pool would be drastically further away from the property line.
Yeah, that's its closest point, yeah.
So I'm just gonna point out, you're hearing some reservation. I don't know if Ms. Littman, if other board members are following her or not, because you never know, but you're hearing some reservations about how the proximity of that pool to the street.
Yes.
I don't know if you want to consider revisiting this plan and coming back to the board with a revised plan to.
Okay. All right, we're going to take a recess and speak to our client.
Can I ask a question though, while we have
I was going to suggest we ask any other questions.
double line that goes around the pool patio, is that a retaining wall?
So that is a actual trench drain that's going to collect the drainage off of the pool patio.
That's what the double line is.
Yeah.
It's because there's a retaining wall detail on the civil drawings. Where does that go?
Yeah, that retaining wall is back here where these plantings are to be proposed, which starts here, goes right along the easement, as a matter of fact.
But it stops at the end of the plants into the trees?
Yes, and then it makes a 90-degree and comes back into the patio just at those steps.
Okay, so going plan east. I don't know if that's truly east, but plan east.
Yes, it goes
Going the other
east.
direction, it stops at the edge of the shrubs?
Yes, yeah.
So it doesn't, so that line that continues on along the backside of the pool is a drain, not a retaining wall?
Correct. Yeah.
You're not able to do anything above the sanitary easement?
We are not.
Yeah, they can't build these.
No.
100% not.
Temporary seating areas, things like that? Nothing, right?
Yeah, they can't build, I mean, a temporary seating area, like they stick a chair out there?
So the,
I mean, technically they could, no one's gonna stop.
How creative could they get?
the board can, or the town can allow, somebody to build like a patio or something, or, you know, anything in the easement, but it is subject to removal at any time by the town.
Yeah,
Like,
so-
if they ever had to
Yeah.
perform maintenance on
So-
their pipe, they're gonna go in there with an excavator and dig up the patio without notice.
And
So-
this
so
board,
here's-
this board can't grant that permission.
That was one of my next questions. Okay, so, because here's my line of thinking. One suggestion is to rotate, right, the pool, or maybe make it smaller, but rotate it 10 feet, right? Which will then open up space on the other side of the pool, which naturally you may think, okay, maybe we'll put some chairs over there. So what's better, to have a pool that close and properly shielded, or have seating areas over there? So then we say, okay, well, maybe we'll say you can't put a seating area over there, you can't put a patio, because that would then be too close to that front yard setback. Is there any way that they can still have seating area? And I was thinking onto that area, but we can't give them that ability, is what I'm hearing, right?
You could in the front, not over the sewer, correct, because it doesn't break in the line where the patio or the pool or something is. Like Mr. Matlack said, they're just coming in and digging.
Well, yeah, they would be at their own risk.
And the town would never allow a pool to go in.
Understood there, yeah, that's understood.
Because you're digging too close to whatever infrastructure is in there.
If you're worried about the street, 10 feet, I don't see it's gonna be a whole lot. Right. If you're gonna allow the pool, I think let's keep it as.
I think it's better than what it is right now.
I agree.
Just,
And I think you put the chairs around, like in an L, along the sides and along the front.
Do you want to take a few minutes?
Certainly.
Could I just bring up just an idea?
You certainly can.
I'm a total layperson when it comes to all this, but it was my understanding that because of the hardship of the sewer easement, that we were gonna ask the board, I guess, in concept, to look at what you're calling the front yard, where our, proposed pool's gonna be, to be more like a side yard and
Right.
treat us like a corner.
Yeah,
'cause
that's
there's
the argument you're going
Yeah,
to make.
that's the, yeah.
That's
and-
an argument.
Yeah.
But it doesn't mean the board has to
Right.
agree with that argument.
Oh, okay.
And
I think
and
I
honestly,
mentioned that.
we're-
as-
you know,
The other thing,
It's all Chinese to me.
Yeah, no, you're right, and that is a hardship that you have, and we just have to struggle with the fact that, okay, how much of a hardship is it? Because, you know,
It's
in my,
self-created.
yeah,
Right. Are there things you can do to ameliorate that hardship?
I got
And
you.
that's what Ms. Lippman is
Yeah.
basically suggesting, that there are things you can do to lessen that hardship.
it may be the people who lived there before you had the same hardship, they did, and they chose, instead of having a pool, they had a hot tub or something like that, that maybe that was how the hot tub ended up there.
Or sold the house.
Yeah. Sold the house to be able to, but, I mean, that's what people do, right?
There we go.
when you're thinking things through, you're showing 27 plants of some sort on shadow lawn between the road and the pool. The ordinance will only permit a hedge 4 feet high in a front yard. So whatever those are, unless you want to look for a variance to screen the pool and patio area, that can only be 4 feet high. So that would be another variance you would need.
Is that only because it's close to the curb?
No, it's because it's within the front yard, within that 45-foot front yard. You can't have a hedge that's higher than 4 feet,
Okay.
okay? Yeah. So.
Okay, so if we can just
The board
take
has granted
2 minutes.
variances for that before, but I just want you to know it would be a variance, which is why I asked to identify what kind of plants they're going to be.
Understood.
You want to take 5 minutes?
Yeah.
Do 5?
We're back on.
We are back, can you take a roll?
We don't need to do a full roll call. We can note for the record that everyone who was here prior to the break is still here.
I am too, and then I get it.
All right.
Okay.
So,
Want me to know?
what?
You want me to say it, or did you?
He said it, we're good.
Say what?
I thought you wanted me to say that
Everybody that was here before still is here. But now,
I didn't know what you were asking me.
if we took the roll, it would be done already.
Yeah, yeah.
All right, do you swear any testimony that you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
And just state your name for the record.
Laura Korn with the K.
Sorry, how do you spell the last name?
Korn.
And you are?
Registered architect.
You're the architect, okay. And you're an RA or an AIA?
AIA.
I never know what the difference is, but I honestly don't know.
You always ask.
Yeah, it's more, but
It's the same
Mark,
thing
I'll
when you
explain
pay
it later.
money.
Okay. Go ahead.
At the July meeting.
No, so I just wanted to point out, we reviewed many different positions for the pool. The reason we kind of put it over here and have more separation from the house was so that the activity that's happening at the pool, the gathering space is closer to the house and farther away from the street. That was the thinking, and if you flip it, you're kind of then moving the noise and the commotion and the kids and everything closer to the street.
Those children.
Yeah, pretty loud.
Yeah, no. You want the children closer to the house.
Right, not to the street.
Yeah.
Yeah, so that was the design thinking for why the pool was positioned the way that we did. But then I guess the thing we were trying to get feedback and what we were just discussing in the hallway was if we were to rotate the pool to bring it closer to the house and have the gathering space on the other side, would we still be allowed to fall within the setbacks that we're showing, which would meet a side yard setback, but is not going to meet the front yard?
Sounds like the question I asked before they went out.
It's not 14, it's 11 or 10.
It's 11 to the patio.
What are you thinking?
Well, just so if we rotate the pool and bring it so it's closer, we always maintain 10 feet from the house for the pool. To have be able to have seating on that area, like if you only have 3 feet of paving, it would be enough. It'd be enough for a walkway, but not to have like chairs and gathering space. So just say if we went 10 feet from the house, another 8 feet for the pool, and then have another 8 feet beyond that to have seating. That would get us to.
But if you imagine an L around the pool towards, you could put seating in the front towards
Saying it would come down here. And
shadow lawn and then along the side also. So it's not all by the street. Because I understand that. I mean,
Yeah.
I completely respect that, but I'm thinking
Okay.
there is an opportunity exists to see in a different formation.
So do you want me to come closer? You sure what you're
No,
saying?
the person who's doing the recording is asking you to speak into the mic, you just texted, that's why.
Oh, no, I just want to see what she's talking about.
But I don't know if it's gonna yell at me.
You're like a coach to me. Play. Here, so if you squared this somewhat, and then you could have this existing space for seating, and then also.
Yes, you're saying like this point's not getting any better, but it's 15.
Yeah, I mean, 10 feet. I mean, clearly, I'm not.
Yeah. No, I get what
I
you're
draw
saying
stick
now.
people.
I know what
Yeah.
you're saying.
Again, you're just
Seating
moving
over
the
here?
activity closer.
Yeah, she's saying
In
put
here?
seating
Right,
here
and
and
then
there
have
and
seating
rotate the pool
here.
that way and keep
And
only
seating
3
here, so
feet.
everyone doesn't have to be
On that side.
right. You can redesign that piece to allow for seating in that L formation.
Okay, but so it wouldn't be necessarily improving the setback at that corner. We would still be requiring a variance for this.
Understood,
Yeah.
you would, but you wouldn't be here. You would now come,
Yeah.
in
No, I get what
here.
you're saying.
And even here you would come in.
Yeah, I get what you're saying.
Thank you.
And you're only putting 3 feet around the one side.
Yeah, I was
You're outside.
suggesting like maybe some seating here and there, so it's not all on the street. That's what I meant when I said that.
So Ms. Lippman obviously
I
has
was
some,
saying on the other side.
Ms. Lippman obviously has some concerns with the location of the pool and the proximity. I don't know how the other board members feel. I have a
Not seeking a
concern.
variance at all.
You have a concern as well. Okay.
Yeah, I understand.
Yeah.
There
I
also.
understand you still will, but I think you could increase the.
We've heard 2 board members have a concern, so I leave it to you what you want to do.
I don't agree that I would move the whole pool and only allow 3 feet on the one side too. And I think all the seating should be on the south and west, not on the east. But that's just my opinion.
He's the builder, that recommendation, I would take not.
Let's just take a little bit of straw vote for you, okay? What do others think on this? Anybody have an opinion?
I agree with the relocation of the pool.
Anybody else have thoughts they want to?
I think it would make
Give
it
some
better,
guidance.
but I wouldn't vote against it the way it is.
Right. I don't have so much an issue with it. I don't like seeing them, especially kids, on the opposite side of the pool.
Right, that's,
I think that's a safety concern.
Yeah, I think if we could talk about ways to shield this really well, having the people where they are in this plan is better than spreading them out, in my opinion. I generally hate voting for pools in these types of situations. I've never done it, but if I were, I would lean towards this one rather than the other way. Do you have, what were you going to do to shield this? So Jim had brought up the fact that these can only be 4 feet high, which is not really shielding, right?
I mean, clearly, it's gonna need, the hedge is gonna have to be more than 4 feet high, and it's gonna require a variance.
Were there thoughts into what the shield, what was going to go?
Yeah, I mean, that was along, we were thinking that there would be a fence and then planting, but if we're limited by the 4 feet high.
Yeah.
Can you grant a variance on height?
Yeah, I was just gonna say, we would be open to it if,
Ford has done that before. There's one on Whale Pond Road there.
yeah.
Yeah.
The house is not on, I mean, it's not really on a corner, so it's not like you can't see because the plants are too high.
Yeah, so it's a good point you bring up. It's not a corner lot, but it's a bend in the road.
Yeah.
So the house has a front property line, a side property, one side and one rear. So there are only 3 sides to this lot. And Mr. Ashkenazi's right, there's no site triangle issue. Because there's no stop control where you have a car waiting to turn somewhere where you have to be able to get a sight distance. So that's just another thing for the board to take into consideration.
If I may, just interrupt on that point, Ben. Speaking of the site triangle, based on the location of this driveway, if we were to position a car, let's say 10 feet back from the right-of-way, and project a line 100 feet out, the pool wall and shrubs just are outside of that site triangle, just to address Ben's concern.
And the way you depict it on your plan too, the cars are kind of entering that driveway from that entrance anyway, and they're exiting the other side. Not that it's controlled to a one-way street in the driveway, but it's just something that the homeowner can manage themselves to.
And the shrubs are coming just on the, what side is that?
So on this side of the pool.
The west side?
Yeah.
And it stops there, it doesn't then turn with the pool at all towards the house?
Currently, we're not showing it that way, but again, if it's a condition, we'd be open to it.
Something this way?
Between the pool and the brick.
And I hate to bring this up, but another consideration is reducing the size of the pool. It's a fairly large pool. And I understand you want that size pool.
I didn't think it was large enough.
All right. Yeah, but it's something you might want to look at. I'm throwing it out. I don't know what the board's feeling is.
I mean, you have, so far as I'm counting, you have 3 board members who have definitely have an issue with the location of the pool. You have 3 are saying it's okay where it is because they don't like the alternative. You need 4 votes. You may seriously want to consider carrying this and seeing what you can do, and maybe come up with an alternate A, and this is the plan we want, here's an alternate, and see what happens. I don't know. I feel bad, but I'm just, not that I'm one to give you advice, and you can proceed and take your chances, but I know what I would do.
Did Mark just count that right?
I heard 3 people definitely said they were not happy with the location of the pool.
I'm not sure.
You're good.
There's only 7 votes.
You're
There are only
good.
7 people up there, but there are
You're
only
good.
7. vote.
I'm good. That's 4.
Who's the alternate?
I'm the alternate.
You're the alternate, so you're better, Chris. You can do it.
He's just here because he's got nothing to do.
Should I count wrong then? So there's 4 votes.
Where are you?
Please said. That's what I said.
Okay, so you're,
And between the house and the pool and on the west side.
On the backside, which
North
is
side,
3 foot.
sorry, whatever side that is.
And I'm okay with the variance for the cottage house.
I would do both. If you ask me my opinion, I would rotate the pool and add the shrubs.
Yeah, well, yeah,
And give
yeah.
a bigger fence, or I'd approve any of that.
Yeah, I'd prove anything on the backside here for shielding the privacy, but I think that you put it over here. You know, here, it's where this all, you know, you see here, the top left down here. You got the space right side over there.
I'm just sliding the pool in.
My concern is that, we're talking about changes, making changes, and we don't even have I don't have a clear list of what the variances are. And I think it's a problem. So to your point, we're either approving it the way it is, or they're coming back. Yeah.
With additional variances needed.
Yeah. Right.
Probably for the shrub.
And if they submit the plans in enough time, then Jim can review it. And if Jim didn't have an opportunity to review these plans in advance of this
Yeah,
hearing.
yeah.
So that's why his report's a little stale. And I think that is in the same boat, so. Okay, got his in, okay. The zoning officer didn't get his in, I guess hers in on time either, so.
Yeah, the zoning officer was on vacation too.
Yeah, that's a surprise.
Wait, did we want to summarize the variances? Because there's the 2 and then the optional 3 with the hedges, right? So it's the rear yard setback, the front yard setback for the pool, and then the optional variance for the hedges.
I'm hearing according to these plans, there are 2 variances that are listed. There is the front yard to the pool, 14.5 feet, correct?
Yes,
And then the front yard to the
paving.
pool surround, which is 11 feet.
Which is 11 feet, that's the second. And then what about the rear yard?
So the rear yard will be to the covered terrace in the back.
So there are 3 variances. We're all, as the plans sit today, there are 3 variances.
And you can have higher than a 4-foot high hedge along the pool on shadow line.
Yeah, so that would be the optional
Yeah,
variance.
And we haven't decided whether we're doing the 2 feet grade or not.
I think you need it based off of what I've seen.
Based on the plan that was submitted, it shows it looks like you need it. If a revised survey was submitted that, if there was an error in the survey, and that variance is no longer necessary, then that could be submitted and that'll address it, but.
I mean, I don't think this application is rising and falling over 2 feet.
No.
Change, no. I mean, that's not like the main variance in this case, so I would just request it, but, that's.
I do have one other thing.
Before you do it, just so I don't lose my train of thought.
Sorry.
In Jim's letter, it says the setback is 37.1, the second floor addition, for the rear yard setback. The plans say 26.4 to the covered terrace, what am I doing?
We revised the plans and Jim didn't.
Yeah.
It was revised, that was one of the things.
So the correct number is 26.4.
Yes, what's on these drawings, yes. Because the covered terrace was moved to the back.
Okay, I'm sorry about it. I just wanted.
No worries.
There was a freshwater wetlands delineation field study submitted, and it referenced a plan, which maybe was submitted, but I didn't get a copy of it. So I just want to make sure that I see that, because there are wetlands on the adjacent properties, and they have a 50-foot wetlands buffer associated with them. So that might could impact the testimony in their favor of why, the pool has to be where it is, but it also may impact whether or not they need a permit from the NJDEP.
Mr. Matlack, where are the wetlands? I don't see a reference to it.
I believe they're on lot 22. Or maybe.
Hi, Ben, yeah, certainly. Let me address that. Peter Richings from Environmental Management, he did go out about a year ago at this point and did a wetland investigation for this property with concern that there might be, there's a drainage ditch which runs, believe it or not, along this area, which is just on the other side of that existing retaining wall. Peter Richings did do some mapping, and Ben, I believe it was in Peter's report, the last page, which shows a W2 through a W5 wetland delineation line. Oh, there we go. Perfect. You can hold that. That'd be great. So that wetland area that is, number one, on the GIS mapping for New Jersey, but also verified by Peter in this area, more than likely there are wetlands there. I did have an opportunity.
45 minutes.
There's a 45-minute timer on that microphone.
Okay, cool. So I did have an opportunity to speak to Richard this afternoon, Peter, about this afternoon. More than likely, we will be seeking a GP8 as part of the home improvement, so on and so forth, permit from NJDEP. The fact that there is an existing patio network in the back of the house now and some other existing features, Peter was pretty confident that DEP would be able to issue a GP8, which is a buffer averaging transition area. Hopefully that answers the question.
Yeah, so outside agency approval is always a condition of any approval by the board. We don't have jurisdiction over, the DEP, but they would be required to get a DEP permit if the board approved their plan.
Okay. So,
Are we doing enhanced landscaping along the border? Did I hear that, or did I not hear that?
I was going to ask the applicant if they've heard kind of reactions. Do you want to push forward tonight and try and get a vote? Do you want to pull back and come and see if you want to sharpen your pencils?
Take note that if the application, just so you know, if the application was to be denied, if you call for a vote, the application is denied, you can't say, oh, okay, let me come back and try to present a different plan. You'd have to come in with a substantially different plan in order to come back from the board. So that's the risk of asking for a vote tonight and having it not go in your favor.
And start over the process.
You'd have to start over the whole process, exactly.
I'm a little confused. I thought there was some indication that there were only a few negatives. Is that not?
I can't exactly tell you how many people will vote for or vote against, but that's why we had the discussion for you to try to keep track of that for yourself to decide whether or not you want to push forward.
It's close. You need 4 votes.
I'm just speak publicly and openly. I don't really want to turn it that way. The kids being on the other side, this is just for the kids. If they're going to be on the other side of the pool, it's also like you can't really control their movements. Like they're jumping out on 2, 3, 4 sides of the pool. I kind of like it where it's like in the corner there, kind of controlled. You can watch where they are. So I would just go for the vote. This is going on for 2 years.
Yeah.
I'm done.
Like,
Okay.
let's just
So,
see what happens.
so
Well, I'm saying like that southwest, right, when you rotate the pool, that southwest as planned, you can move the seating area down there.
Right, but there's
There's
still going to be significant, we did do it originally.
Put surround around the back of the pool like most pools have, and
Well, I'll just show you, we did it originally, and it's just this just becomes this open, kind of like a no man's land here. I don't know,
Can I ask a question? Can we break the vote up for the addition and separate out the pool? No, you can. I mean, I've seen that done before.
What's the addition?
We've done that
The
before.
extension?
So.
I don't think we have a variance on the extension.
The house itself doesn't require any variance.
Oh, it's just the pool area?
Pool area, yeah.
Okay, so the answer is it's irrelevant. But you could.
I was trying to help
Okay.
them move forward with something versus
I'm just,
at least
Okay.
saying yes to a portion of it and not holding the whole project up on you, but.
All right, so what kind of screening for the pool would we want to have included if we were to approve this? That should be part of the application.
it's up to them what
Meaning-
they want.
yeah, but-
we can't do it. I'm just to put my 2 cents in, if I were doing this, you've been hit with a lot of information tonight. And if it were me, I'd want to take a couple weeks anyway to think it through, to make sure I'm making the right decision, which direction I want to go. It's
Totally respected, but like I said, we've been literally doing this for
Yeah,
2 years.
I
We've
I
been-
mean, if they deny your applications, you're done. I don't know, I don't know why.
Mark,
you want
Mark,
to-
I think they've heard that. They've heard that.
I just don't know that they've heard.
By turning it, it's substantially different.
We also don't need to scare them out of getting a vote, okay? I mean, it's a bit much.
Sometimes it's just when someone.
I know, but you
someone
said it
comes
4
in-
times.
When someone
and-
comes in without an attorney, sometimes they don't fully comprehend what
Yeah.
it is that
Okay.
we're saying.
Yeah.
Because they don't understand the legal side of
You
it.
have an obligation to reiterate yourself and make sure that you fully understand the process and what you're doing. So I don't think Mark is badgering you, Mr. Lexstein is badgering you.
No, I'm not. I'm not badgering me at all.
Serving the record, whichever way it goes, so we can say you were fully informed. That's-
Whatever the boss says.
Oh, boy.
You want to vote?
No, I was the boss.
Tammy, what do you think?
I
You didn't know you were the boss?
I don't know. I feel we've been
Either we
doing this-
vote or don't vote. Come back another month. I don't really want to do it the other way. I'm kind of over it.
I think this is the safest way for our children and whatever guests come over and are in the pool that I'm responsible for. And that's the best that I could supervise, and that's what I'm comfortable with. And I wouldn't feel comfortable moving it another way where the kids are farther away from me. And that's just from me, a mom's point of view. I take complete responsibility for whoever comes into my backyard. And yeah, we've been working on it for a couple of years. And I think that we should just see it through tonight. I really do. I mean, but what do you say? What's your final?
You're the boss.
I
mean, I don't.
That way
I
he
don't-
can't get in trouble
Like
later on.
it's not posing a safety threat to anyone in any way. I mean, it's just. I mean, it's fine. Like.
I'm with her.
I mean, is there any?
No, it's all, it's a,
We tried to.
Yeah.
The reason being that we try to make the setbacks, as big as you can, considering the odd shape of the property, the small
Right.
property, and the hardships involved. So, just be, in fairness to you, your neighbors, and any other application. We just don't want to see, me, and I think some members of the board in certain circumstances don't want to see something abutting the street. They're so close to it.
Right.
That's when there's an opportunity to move it in and compromise.
Right.
That's
So
all.
I mean, there's other options, right? I mean,
An opportunity for compromise.
you
That's
could
all.
put in a swim spot or a hot tub, right? You're putting in a pool, but I understand why you want a pool. I have a pool, I love it, but there are other options, right? You could put a hot tub in or a swim spot
Well,
or
it's really-
reduce the footprint of the pool.
no, with all due respect,
You
it's just
don't-
for the kids, so I'm
you
like,
don't
they're not
have a
gonna go
legal-
in a hot tub.
With all due respect, you don't have a legal right to a pool.
I understand that.
So that's what he's basically saying.
Mr. Higgins.
Yes.
Is there room as is to put a hedge like arborvitae's in there, like a deer-resistant arborvitae?
There's room to put a hedge along the street, yes. You don't want to put there's some arborvitae's that grow 20 feet wide and 40 feet high. You don't want to do that. But there's room to put a hedge there. There's a variety of different plants. And that's something, if you do vote for it, I would say that you have to make a condition, they submit a landscape plan that's acceptable to Ben and I.
I don't see anybody here objecting to their plans.
You're not downtown.
Yeah, okay, all right, so Okay, if there's nobody from the audience to ask questions or testify or give comments, so we're going to close the public hearing.
I think, you want to say?
No, I was confirming with them, were they open to adding higher hedges along the southern portion of the pool, and they agreed.
Yeah, okay. So I would offer for positive resolution, the plan as it is, adding to it you would have to give to Jim and to Mr. Matlack, a planting plan, right? That shows, plantings taller than 4 feet.
Yeah, but do you want to put a height limit on it?
Well, that's what I was asking before. 10-foot height
I would
limit?
say 8 to 10 feet.
Okay, and then that's along the street, and then I would also like to see it head towards the house as well.
Like the southern side of the.
The southern side, yeah. So as you're coming along the Shadow Lawn, if you look to the left, you will not see that there's a,
Yeah,
yep,
that's
exactly.
correct.
All right, so you want it 8 to 10 feet
Yes.
along the
Yeah,
street.
it has to be maintained at 8 to 10 feet.
Right, so it's gonna have to be sprinklered and make sure that it is
Yeah. Planted 5 to 6 feet and maintained at 8 to 10 feet.
8 to 10 feet. It's
Have
gotta
a
be
great
sprinklered and it's got to, and then it's gonna run. Mr. Fuller, Chairman, I just want to make sure I understand. When you say go back towards the house, you just want it coming down the property, correct? Is that what I'm hearing you're saying?
Coming across.
Yeah.
There's a dot, I think that's a fence line? So, is that
Oh,
what
he
that
wants
is?
it to swing, you want it to swing in?
Yeah.
Yeah.
Okay, I got it,
So
I got
somebody
it.
riding.
Yeah, yeah,
down
so you,
Shadow Lawn, yeah.
so on the outside of that
Yeah,
fence
yeah,
area.
yeah.
Okay, understood.
I'll second that.
Mr. Ashkenazi?
Yes.
Mr. Chimara?
Yes.
Ms. Lippman?
No.
Mr. Puglielli?
No.
Mr. Luneski?
Yes.
Vice Chairman DeGenaro?
No.
And Chairman Fuller?
Yes.
So that's,
4 to 3.
that's 1, 2, 3, that's
4 yeses.
4.
It's 4 yeses.
Hardest no I've ever
That's
had
a-
to give, by the way. I just wanted to
so
point
much.
that out.
Appreciate it.
Honestly,
Like,
I'm happy for you that it got voted through, but I
Thank
couldn't.
you.
Respect your opinion.
I just want to say that we, like, aside from all this, we recently became official residents of New Jersey, even though we've lived in the house for 10 years. But I'm saying we really appreciate all the care that you guys take care of the town, and we love it. So thank you.
Great, thank you, welcome.
Thank you.
Have a good night.
Motion to adjourn.